With due respect, my lord, I'd like to mention one application for restoration.
Yes. Need. Group 2.
With due respect, my lord, I'd like to mention one
Group
application.
2.
Restoration, group 2.
May I mention one matter for upgradation, my lord?
No.
My lord, may I be permitted to mention a matter? My lord, this mentioning was done on the last occasion, my lord. It was allowed upon serving notice. Now, my lord, the issue is that my lord's court officer sent a requisition in the mandamus section, but the file is lying in the NRD section, my lord. It was dismissed for default. Now, kindly allows this.
Number 2 नहीं है.
China detached.
Item 60 of the today's list.
आज की कौन सी तारीख? Yes.
Item 60 of the today's list. This is an extreme urgent matter because I have been transferred from the present school about 100 kilometers far away, arbitrarily and whimsically.
No. Yes.
To mention one matter, the
No.
petitioner filed this instant writ petition for correction of his date of birth in his service book in virtue of order passed by this.
What is the item number?
Not in the list.
Give the list.
My lord,
No, aske korche.
My lord, both parties are here, my lord. With having consent, my other side, my lord, hundreds of matter, my lord, I have done in this regard, my lord. Similar issue, my lord, it matters appearing as item number 1134. It will take only 1 minute time, my lord, because from Monday, if you also could not take this matter on within my lord Friday, the matter will affect us, my lord. My lord, both parties are here. My lord, having consent, my lord, it will take only 1 minute time.
No. 1 minute. What 1 minute?
Similar orders might have been passed. My lord, Justice Bhattacharya, my lord, Justice Amrita Sinha, my lord, similar matter, my lord. 1134, my lord. Any day, my lord. Before my lord, before Monday.
No, what is the matter?
Matter is, my lord, I'm working as a my lord Sampur Sarok in a Madhuri Shikha Kendra. My lord, due to the arbitrary act of the state government, my lord, I have lost my 5 years of service. My lord, subsequently it has been held by this honorable court as the benefit that was to be given to us, my lord. It has not been given to us, my lord. So the state government will revert get back that 5 years of service. Return back that 5 years of service, my lord. Settled issue, my lord. Hundreds of matters have been done.
How it will be infructuous?
My lord, if the benefit that was to be given for the para teachers, my lord, if that was given to us, my lord, I will not get back that 5 years of service.
So afterwards we'll hear.
My lord,
Seriously we'll hear. Afterwards we'll hear.
My lord, the EPA will be given for Monday.
Not now.
Yes.
Yes.
My lord, both parties are here, my lord. Having consent of both the parties, my lord. Kindly, my lord. It will take only 1 minute time.
No. Yes.
The gentleman will lost 5 years of service, my lord. Kindly, my lord. Kindly appreciate, my lord. I never.
I'm appreciating. It will be taken up.
my
Primary matters.
Coming next week.
Primary matters.
Yeah. Next week mention.
my lord,
Contempt application.
After 9th, huh? Inclusion. Yes.
my lord, for non-prosecution.
Yes.
Prosecution.
This is for contempt application.
Arising out of which order?
For inspection by the contact authority, lordship.
Where is the order?
Yes.
Huh? Release me.
But may I be permitted to mention, my lord, item number 76, 72 of your lordship's list. Last item.
Yes.
My lord, yesterday, my lord, I got a leave, my lord, from your lordship's, my lord, to move the matter, my lord, today. Matter pertaining to the, my lord, D8 special education candidates. They are trying, they are seeking, my lord, permission to participate in the process, my lord.
yesterday your lordship was pleased to give direction in another writ petition allowed the candidates, my lord. My lord, I want similar relief. They are the DLED from RCI.
Okay.
I have a D.Ed from RCI special education. Let the any time, my lord, today, my lord, let the matter be taken up.
How many matters are there? We'll go serially. If it is reaches, we'll pass similar orders if they are having the similar qualification.
Yes.
Huh? If you are similarly circumstanced with the
Yes, similar circumstance.
petitioners of Mr. Laidi, then
Yes.
who is up for the state? Mr. Nannal is there?
I shall again serve on them. But I
Who is
mentioned
for
the
the
matter.
state? Who is for the board? Rather,
Board,
Mr.
my lord,
Nannal appears for the board.
Kaushik Chaudhary.
Find out. We'll go serial in their matters. We'll take it up.
In the list, there is an indication that matter, the miscellaneous matter will taken up, my lord, on Friday
Friday.
from 69 onwards. In your lordship's leaves, my lord, there is a note. Kindly see motion for miscellaneous Friday.
Yes.
I am harping. That's why, my lord, last date, my lord.
The note has been given on Friday. Then
No.
we'll take it
Last
up on
date for
Friday.
filing application, my lord, on 2nd November, yesterday.
Ah.
That's why I mentioned.
So day after tomorrow we can take it up, or serially if it reaches 72 we can take it up today also.
Obliged. Get from ঠিক আছে
এখন আমরা কোনটা ডাক কন্টিনিউইং ম্যাটার হ্যাঁ বেশ
কিছু বলতে
কন্টিনিউইংটা কোনটা ছিল 69 ঠিক আছে তাহলে ঠিক আছে 69টা করে আমরা মিসেলেনিয়াসটা কালকে আর নেব না মিসেলেনিয়াসটা আমরা 5 তারিখেই নেই ফ্রাইডেতে নেই কিছু মনে হচ্ছে 4 তারিখে কিছু একটা ওভার হয়ে যাচ্ছে
কন্ট্রাক্টটা তুমি গরম করে থাকলে পুরো
কিছু আছে না দেখি কি হয় আজকের দিন ইয়েস
This matter, my lord, the petitioner has retired from service year 2024 and till now he has not received any pensionary benefit.
what is the item number
Item number 222 on the last day's daily and 226 on the monthly daily. Today the matter is not there. It is a pension benefit.
It's pension
A pension matter.
pension matter it will not be there today it will not be there
It is not there, my lord, but
it will not be there today
my lord, there is a great.
it will be on Monday and Tuesday your matter will appear we will take it up serially don't worry yes sir
May I permit to mention one contempt application, Lordship.
arising out of which order
Arising out of my Lord's order, Lordship, dated 5/3/2025. There was a direction upon the respondent to serve, Lordship. The matter has been heard once.
wait well the order
What a my Lord, Lordship. There was a direction by Lordship to serve the alleged contempt. Serve the alleged contempt.
the order has been passed isn't it?
Lordship, there was an order for serving upon the alleged contempt.
oh file a document to the postal authorities this has been served
Served.
released karo okay document
Lordship, may
no upgradation
Your Lordship, may I permit to mention on matter for inclusion. Your Lordship, this is the pertaining to extension of an interim order. Your Lordship, on last occasion when this court was not sitting, the urgent determination went to Honorable Justice Amrita Sinha. She heard the Honorable Justice heard the matter and extended the interim order till 12th of December with the direction that the matter to be listed on 3rd December. Your Lordship, the matter has not come on list as of yet.
you know
My Lord,
What is
item
the order?
is a very short matter.
Order.
My
Your
Lord,
Lordship,
can
I
we
have annexed. I will mention again tomorrow. Your Lordship, I have not annexed.
Restoration.
order
Restoration.
restoration of
Petition for restoration, my lord. 1911, 19 November, my lord, 2024. I didn't come to the court and on this ground, my lord, dismissed for default. But only restoration application.
distribution default of which application contempt application was dismissed for default
Dismissed for default. Contempt application was dismissed for default.
so where is the order
Contempt means municipality matter, my lord. Municipality matter, order passed on 2020.
I am not taking up municipal matter this court has no determination for municipality matter
contempt application, my lord, retired and transfer job transfer matter is issued on 2020.
Who passed the order? When we come up with the order, I do not have the determination. If it is passed by any judge who has retired from service or transferred, it will be taken up by a particular bench which has been given the determination.
My lord, item 2 is a bit.
May I be permitted to mention one primary method for inclusion in the list? Primary method for inclusion in the list.
Inclusion in the list.
Inclusion. Yeah.
My lord, item 2 is a very short matter. Very short matter.
Item
2. Only 2. Today's list. Main matter has already been disposed of for non-prosecution. Is a prayer for getting the amount which was kept with the district magistrate. Nothing more.
not now. দেখো যেটা আছে সেটা রাখুন। এটা কন্টিনিউ। দেখো সিপিএন কেউ আছে কিনা?
Well, I'm for the petition led by Mr. Ahmed.
This will take some time. Well, my match will not take more than 30 seconds.
তো ওয়ানটা দিয়ে দাও।
One.
My lord, I am for the DPSC Malda.
কত হচ্ছে?
One.
1 হচ্ছে? 69.
We'll take it up. Where is Mr. Ahmed?
He's coming.
Well, let him go.
He's coming from that building.
That this is my written instruction. Well, only one.
Matter is appearing under the heading
Well, only one difficulty.
to be mentioned. Mr. Ranjan Bhattacharjee, learned advocate for the petitioner, submits that the petitioner does not intend to proceed further with the present writ petition. He seeks for withdrawal of the instant writ petition.
My lord, in the-
While written instruction.
My lord, in case of leave, my lord, I have objection.
In this matter, my lord, I am appearing on behalf of the state.
The erstwhile advocate, who has filed the writ petition, there are certain mistakes.
Okay.
And that is why, I want to file it today. After correcting the mistakes, I want specific leave from your lordship. Otherwise, I cannot file afresh.
My lord, in the writ petition itself,
What is this matter about?
my lord, the issue is that he has challenged the order passed by the disciplinary authority imposing a penalty of withholding 3 increment with cumulative effect. And that was under challenge in this particular writ petition. My lord, entire,
What is the mistake then?
my lord, have late, my lord,
What
have,
is the mistake?
yes, everything has been annexed, or every order, every, my lord, the communication has been annexed.
Then?
Why? I have a strong objection, my lord, if there is a leave. If he is short for leave, then I have a strong objection.
It is my petition. I may be allowed to submit for 1 minute. The rule has been wrongly quoted. The rule should be 2001 disciplinary rules, under which provision the impugned order has been passed. In the writ petition, the learned advocate has mentioned the act of primary, which has not the subject matter of the writ petition. It cannot be. Under the act, this disciplinary rule is not there. The disciplinary rule is of 2001. The act is of 1973. This is
Which
number
paragraph?
1.
Which paragraph?
And my lord, the
আরে বাবা আমার মামলা তুমি
আরে ভাই আমি তো একজন পার্টি
ভাই,
কি না তুমি এমন করছো মানে আমাকে আমিও তো একজন
Please
party,
don't
দাদা।
argue like this.
এই,
There is in which
মানে why
paragraph it is stated.
মানে I am also a affected party, I have a right to audience.
Let him place.
Yes,
If it is wrongly
Yes.
been stated in the writ petition,
my lord,
we'll decide.
তুমি কি নোমিনেশন নিয়েছো এটা
দেখো,
তুমি
দিয়ে দিন।
শান্তি সরকার দেখাচ্ছে
Oh, one minute here.
you will get your chance.
You keep it with you. For the timing, let's see.
Very well. Your lordship can have a look to page 17, paragraph 32. Provisions under section 37, 40, 41 of the West Bengal Primary Education Act, 1973.
Yes.
And in terms of the rule made thereunder, the council has not established, and as such, the chairman concerned has no power or authority to form the disciplinary authority. But this is not my case. Now your lordship kindly turns to the last page, last annexure, page 110. 25th of September 2025. This is under challenge. Well,
20
this order has been passed in terms of the disciplinary rules of 2001. That has been mentioned. First paragraph, office order, GO number 906, 9th of September 2001. Well, got it? Yes. Now, the point of challenge should be on this. Why this recent order has not been properly, or the office order dated 25th of September is not permissible in law, under which provision of the rule. Rule 9 has not been considered. The rule 9 mentions Rule 9 mentions the formation of the disciplinary proceeding and the outcome of the disciplinary proceeding. It has not been mentioned. There is some problem.
Okay.
If I file afresh, how my learned friend is prejudiced?
Now, my lord,
he is appearing for the council.
yes,
Council.
my lord, we have,
Ashun.
my lord, only one thing.
But this is
My lord, the paragraph that my lord learned
That-
friend has, my lord,
The act has been wrongly quoted in the writ petition. He seeks for withdrawal of the, he files a written instruction, seeks to
My lord,
withdraw
okay.
with leave to file afresh,
only my lord,
It's
I am
been
making one
instruction.
submission, your lordship.
which is taken on record.
My lord,
Learned-
here, my lord, kindly, my lord, my learned friend has, this instruction has been addressed to Anita Shah, but here the advocate on record
And
is.
I have taken no objection. Why he is so agitated? He is appearing for the council, primary council.
Because, my lord, as it appears from the record.
I know.
Instruction submitted by the petitioner, which is taken on record.
And the,
In view of the above, in
my lord,
view
my
of the above,
objection to be recorded. But
learned
have
advocate
given
for
up.
the, which council this is?
my lord, DPSC, mal.
DPSC Malda object to the withdrawal of the same. Leave creator দিয়েছেন উপরে? In view of the above, the writ petition being number WPA 25531 of 2025 is dismissed as withdrawn with liberty, with leave to file afresh.
I'm grateful. I'm so grateful to you. Grateful.
Yeah.
And
69.
my lord, the paragraph my learned friend has shown before your lordship.
Huh? $69 টা ধরো।
জাজমেন্ট বার করো, আমার বই আছে বই এসছে, জজ সাহেবকে দিলাম, কি দেখে 2025 yes.
নোটের কাগজটা
Yesterday, your lordship granted us leave to file opposition in the against the application for addition of party. My lord, we have prepared the opposition. I am filing.
দিয়ে দিস নি আগে, অনলাইন দিয়ে দিবি তো, তাহলেই হয়ে যায়। কিন্তু আজে বাজে বলতে পারে না, অনলাইন দিয়ে দিলেই তো বলতে পারে না। দিক কই, আমার বই কই?
Yes.
মানে আমার ব্রিফটা দে। Well, I have placed the facts. Now I will judgment, cite one or two judgments.
Yesterday you were citing 2025 SCC online. SC
No, today I'm not citing that. I will cite some other judgment. Your lordship's kindly. Will you delete that? That should be, my lord, 2025 2 SCC, page 1. (2025) 2 SCC, page 1. My lord, before handing up to your lordship, I just, in a nutshell, my lord, I sum up the facts. My lord, rule says as on the date of the notification, recruitment notification, one must possess the qualification. Advertisement is also say so. Well, just for repetition, I will not elaborately repeat it, but your losses kindly have a look at the এর দুটো পেজ আছে বোধহয় নাকি বই আর একটা সেকেন্ড ভলিউম আছে বোধহয় Well, kindly take up the 26947 notification.
Which volume?
Just a minute, ma'am. হ্যাঁ
ঠিক আছে
না এটাও তো না
নোটটা 2 মিনিট আছে
No, yes, losses got it. 100, Malad, 104. No, এটা তো নয়। এই তো নোট, just a minute, I'm missing something. তোদের ইমপিউন নোটিফিকেশনটা কোন পেজে জানো ভুলে গেলাম 500 কত
397
তাহলে কার থেকে দেখালাম
Can you probably you have shown it on can.
Oh, I'm sorry. Well, kindly take up the application that would be proper. It's handy because he has number of petitioners. That's why it has become bulky. কতগুলো 500 petitioner? That's it. Well, kindly take up the can. That's why I took the assistance of the can. Now, your losses will find recruitment notification 160. 25 September 2025 at a list of dates ছিল না just I will point out two things then I will take your losses to the judgment. Number I just placed the first paragraph. The West Bengal Board of Primary Education invites applications from the eligible candidates for the recruitment of primary teachers in the state in accordance with the provisions of the West Bengal School Teacher Recruitment Rules 2016 against the vacancy position 13,421 for the post of assistant teachers. Why I'm emphasizing it? First, from the eligible candidates, which has been enumerated in the below. Second, your lordships, this will be governed by Recruitment Rules 2016. Therefore, advertisement has to be read with Recruitment Rule 2016. And your lordships, vacancy have been declared. 13,421. Now, your lordships, if we go little, clause 3 qualifications requirement, your lordships here will not find that the pursuing candidates were allowed to apply for. Clear to your lordships? They are pursuing. The pursuing candidates, they say, we have to be allowed to participate in the recruitment process. Eligibility qualification do not prescribe for that. Only passed. Kindly see, my lord. B. The candidate must have passed.
Yeah.
So, running comment. So, my lord, as on the date of this notification, if a candidate have not passed the any of the qualifications, he cannot apply for. That's the. Now your lordships will not find anywhere. These are the things. Now your lordships kindly take up the rules. Rules Mr. Vishwas has hand up the rules, your lordships. Just for a moment. 139 will be only.
Judgment
139. No, not 139. Rules. Yes, rules is at 127.
129.
120. 127 it starts with.
Yeah, starts with.
129 is the.
The relevant provision will be at page 129, sub-rule 2 of rule 6.
Yes.
The candidate shall possess the minimum educational and training qualification as prescribed by the NCT prevailing prevailing as on date of publication of the recruitment notification. My lord, if we read these rules, read with my lord recruitment notification, my lord, one have two pauses on 25th September 2025, whatever the requirements of the rules, and prevailing on that day published by the NCT. My lord, rules, neither the rules nor the, my lord, advertisement, recruitment notification, prescribing, allowing the candidates who are pursuing any course, they are pursuing DLED course, any course. So rule, neither the rule nor the advertisement permit them to apply for. They are now praying that before your lawsuits by way of this thing. I think there will be no quarrel in regard to this. Now, my lord, on this factual background, I am citing one judgment on the proposition that rules of game cannot be changed. Rules according to the law settled, as soon as the notification published, my lord, the recruitment starts. Initiation of the recruitment starts. Thereafter, the rules of game cannot be changed. My lord, this is the settled law. On this proposition, I am citing, my lord, 2025 2 SCC, page 1. Reported judgment. You understand? ওর কাছে আছে, ওরা প্রচন্ড টেক্সার চেঞ্জ করে দিতে পারে সব, এত টেক্সার।
Yes.
Now your lawsuits, just I will give your lawsuits certain paragraphs and then I will take your lawsuits to the last issue. Now, my lord, kindly see the paragraph 1. A 3-judge bench of the court, while accepting the salutary principle that once the recruitment process commences,
Yes.
12, page 12, page 12, my lord. A 3-judge bench of this court, while accepting the salutary principle that once the recruitment process, this is constitutional bench judgment, principle that once the recruitment process commences, the state or its instrumentality cannot tinker with the rules of the game insofar as the prescription of eligibility criteria is concerned. Wondered whether that should apply also to the procedure for selection. In that context, doubting the correctness of a coordinate bench decision in K. Manjusri for not having noticed an earlier decision in Subodh Chandra Marwa by order dated 20th March 2013, it was directed the matter to be placed before the Chief Justice for constituting a larger bench for an authoritative pronouncement of the judgment. Manjusri said that once the recruitment process is, you cannot change any of the conditions of that. There are two conditions normally, Malad, that has been commonly, Malad, in service jurisprudence. Once in eligibility criteria and another is procedural part, how to be selected. This, one is the eligibility criteria and the other is procedural part. This judgment also says that. Now, Malad, kindly come to just a minute. Let kindly come to then you'll see paragraph 9. Some of the unsuccessful candidates filed writ petition before the High Court, questioning the decision of the Chief Justice of the High Court in fixing the cutoff at 75% on the ground that it amounted to changing the rules of the game after the game is played. The High Court on its administrative side defended the decision of the Chief Justice by claiming it to have been taken in good faith for appointing a suitable candidate. But pause here for a minute. As I submitted before, Lordship, one is the eligibility criteria and the procedural part. What this Honorable High Court did, your Lordship, the Honorable Chief Justice, there was no fixation of mark that up to this mark they will be called for interview. There was no, neither in the rule nor in the advertisement, but they did it, the Honorable Chief Justice. Now the question came up, does it amount to change of the rule of the game? This is the basic question. Now your lordships will find paragraph 13. Public services broadly fall in two categories. One, where services are in connection with the affairs of the state or union. Second, where services are under the instrumentalities of the state. These are the services under the instrumentality of the state. Teachers are appointed by the council, recommended by the board as a body and appointed by the council. In either category, law governing recruitment must conform to the overarching principles enshrined in Article 14 and 16 of the Constitution. In various judicial pronouncements, the law governing recruitment to the public services has been colloquially termed as the rule of the game. The game is the process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an oft-quoted legal phrase that the rules of the game must not be changed midway or after the game has been played. Broadly speaking, these rules fall into two categories. One, which prescribes the eligibility criteria and of the candidates seeking employment, and the other which stipulates the method and manner of making the selection amongst the eligible candidates. We are on the first proposition. Rule and the advertisement, by way of advertisement commences the selection and prescribing what are the eligibility criteria. What they are praying for, that is against the advertisement. Then your losses, clause paragraph 15. Cut-off date with reference to which eligibility has to be determined is the date appointed by the relevant service rules. Where no such date is provided in the rules, then it will be the date appointed in the advertisement inviting applications. And if there is no such date appointed, then the eligibility criteria shall be applied by reference to the last date appointed by which the applications are to be received. My lord, kindly allow me, after placing this judgment, to elaborate this point of, I will advance this point. Then your lordships will find, my lord, kindly paragraph 18, my lord, 18, 19 and 20, my lord, your lordships, respective submissions have been considered by the Honorable Supreme Court. My lord, I am not going into this. I am straightway going to the analysis of the Supreme Court. My lord, that's at page 28. 21, sorry, my lord. Analysis. I am skipping over the respective submissions to cut short the matter. 21. To effectively analyze and adjudicating upon the questions referred, we would divide our discussions into the following parts. When the recruitment process commences and comes to an end. 21.2. Basis of the doctrine that rules of game must not be changed during the course of the game or after the game is played. C. Whether the decision in K. Monjusi is at variance with the earlier precedents on the subject. D. Whether the above doctrine applies with equal strictness qua method or procedure or for selection as it does qua eligibility criteria. Very vital, your lordships. Whether the procedure for selection stipulated by the act or rules framed either under the proviso to Article 309 of the Constitution or a statute could be given go by.
Yes.
This is another point. Whether the appointment could be denied by change in the eligibility criteria after the game is played. 22. Commencement of the recruitment process. The process of recruitment begins with the issuance of the advertisement. This is the finding of the Supreme Court, my lord. And ends with the filling up of the notified vacancies. It consists of various steps like inviting applications, scrutiny of applications, rejection of defective applications, or elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of list of successful candidates for appointment.
Yes.
Therefore, my humble submissions, kindly allow me to pause a moment. We had the rules of game, has started to play as soon as I advertise that. Then your lordships will find the basis of the doctrine. I am just, the basis of the doctrine, I think, this is based on Article 14 and 15, that it cannot be changed. Your lordships may have a kind of a glance of that. It's totally based. One paragraph is suffice. 23. The doctrine prescribing change of rules midway through the game or after the game is played is predicated on the rule against arbitrariness enshrined in Article 14 of the Constitution. This is the views of the Honorable Supreme Court. Finding. Article 16 is only an instance of the application of the concept of equality enshrined in Article 14. In other words, Article 14 is the genus, while Article 16 is the species. Article 16 gives effects to the concept of equality in all matters relating to public employment. These two articles strike at arbitrariness in state action and ensures fairness and equality of treatment. They require that the state action must be based on a valid, relevant principles like to all similarly situated and not to be guided by any extraneous or irrelevant considerations. In all its actions, the state is bound to act fairly in a transparent manner. There is an elementary requirement of the guarantee against arbitrary state action, which Article 14 of the Constitution adopts. A deprivation of the entitlement of private citizens and private business must be proportional to the requirement of the ground in public interest. I am not taking up all. It ultimately helps that any change will be contrary to Article, guarantees contrary to Article 14, because it will be arbitrary. It will give hands to the authority to act arbitrarily. Once I publish this, I cannot change it. There is no law, my lord, regarding that a pursuing candidate to be allowed, either in the advertisement or in the rules. Then your lordships kindly see paragraph 29. The headline is sufficient, I believe, my lord. K. Manjusri is not at variance with earlier precedents. And just give your lordships one paragraph. In K. Manjusri, the recruitment exercise was for selection and appointments to the post of district and session judges grade 2. The extent rules, I believe, my lord, your lordship in the administrative side sometime have gone through this judgment, Manjusri.
Yes.
Because your lordship has to perform some administrative job also.
Yes.
The extent rules prescribe the eligibility qualifications, but were silent on the procedure for selection. The manner and method of selection was therefore to be decided by the High Court for every selection as and when the vacancies were notified for selection. The vacancies were notified by the state government. As per the advertisement for a selection, a written examination followed by an interview were to be held. By resolution dated 30th November 2004, the Administrative Committee of the High Court resolved to conduct a written examination for 75 marks and interview for 25 marks. It was also resolved that the minimum qualifying marks for open category or unreserved category, backward classes category, scheduled caste category, scheduled tribe category candidates shall be prescribed earlier. Following the High Court's direction, written examination was held and results were declared, wherein 83 candidates were successful. Interviews were held. Thereafter, the marks obtained by those 83 candidates were aggregated and a consolidated merit list was prepared in the order of merit on the basis of aggregate marks. The merit list inter alia contained marks secured in the written examinations out of 100, marks secured in the interview out of 25, and the total marks secured in the interview out of 125. Based on that list, the Administrative Committee approved the selection of 10 candidates as per merit and reservation. I'll pause here for a moment. Paragraph 29 specifically recorded that so far the procedure, there was no rule. Your lordships will find that. The manner and method was therefore to be, the extent rules prescribe the eligibility qualification, but silent on the procedure and selection. Is also getting 29. But therefore it cannot be without any procedure. High Court in its administrative high committee laid down a procedure. That's 29. Elaborately dealt with. 30 your lordships will find they, after the process is over, they adopted a different method for selection out of 83. Kindly see your lordship. What are the different? Paragraph 30, last 4 paragraphs. The merit list inter alia contained marks secured in the written examination out of 100. Marks secured in the interview out of 25. The total marks secured in the written interview out of 125. This was not in the procedure prescribed by the High Court itself.
It was 75 and 25.
That's your losses. So this is stood the change of the game. This is procedural part. 31. However, the full court did not agree with the select list prepared. Consequently, the Chief Justice constituted a committee of the judges for preparing a fresh list. The committee recommended that in place of 100 marks for the written exam and 25 marks for the interview, the candidate should be evaluated with reference to 75 marks for the written examination and 25 marks for the interview, in line with the earlier resolution. The committee also recommended that the minimum percentage marks applied for the written exam to determine the eligibility of the candidates for appearance in the interview should also be applied for the interview marks, and those who fail to secure such minimum marks in the interview should be considered as having failed. Based on the recommendation of the committee, the minimum percentage on that. Then, I'm not going into paragraph 32, 33. In that factual candidates, 2 candidates whose name found mentioned in the first list and who got excluded in the second list filed writ petition. Because your losses, paragraph 32 is also at variance. So far, that was his concern. Okay, to determine another barrier was given, the interview marks. Then your losses, kindly see paragraph 34. Key observation of this court in Manjushri was being extracted. The interview committee conducted interviews on 13th March 2006 on the understanding that there were no minimum marks for interview. Clear your losses. Paragraph 31, your losses fine. After the Chief Justice, my lord, the then full court did not agree, but the full court again, my lord, went on wrong in doing minimum marks in the interview. That was also not prescribed, my lord. Then the Supreme Court says that was also wrong. That was also amounted to rule change of the game. These judgment your losses will find paragraph 35. The discernible ratio in K. Manjushri is that the criterion for selection is not to be changed after completion of the selection process. Is also getting it? Though in absence of the rules to the contrary, the selection committee may fix up minimum marks, either for written examination or for written interview or for interview for the purpose of selection. But if such minimum marks are fixed, it must be done before commencement of the selection process. This is vital, my lord. This is the ratio of Manjushri. This was referred to before the constitutional bench about questioning the doubting the correctness in because it didn't consider the earlier one judge. Then your losses will find paragraph 36. What is important in K. Manjushri is that the minimum marks for the interview was fixed after the interviews was over. Well, this was procedural part. Now what they're asking, eligibility part. Change the allow the pursuing candidates. Now the Manjushri judgment was upheld by this. Malad, kindly come to, I'm not taking all. I think your losses. Paragraph 65 will the entire thing your losses will be getting. Kindly similar conclusions. We therefore answered the reference to the following terms. Recruitment process commences from the issuance of the advertisement calling for applications and ends with the filling up of the vacancies. Yes. Eligibility criteria for being placed in the selection list notified at the commencement of the recruitment process cannot be changed midway.
Yes.
With the recruitment unless the extant rules so permit, or the advertisement which is contrary to the extant rules so permit, which is not contrary. Well, kindly have a look. Advertisement says recruitment rules 2016 to be followed, and they say in the clause, candidate must have passed on the date of advertisement. So, this is the ratio of the judgment that their prayer is contrary to the law. Now your losses, only one thing, just kindly take up this judgment, your losses once. Only one paragraph, paragraph 15, if I'm not wrong. Just. 15. Cut-off date with reference to which eligibility has to be determined has your lordship got done, is the date appointed by the relevant service. When no such cut-off date is provided in the rules, then it will be the date appointed in the advertisement inviting applications. And if there is no such date appointed, then eligibility criteria shall be applied by reference to the last date appointed by which the applications were to be received. Similar, I take your losses one, the rule segment. Rules. Kindly take up. Well, kindly consider rule 2, sub-rule 2 of rule 6. The candidate shall possess the minimum educational and training qualification as prescribed by the NCT, what I'm saying, prevailing as on the date of publication of the recruitment.
Yes.
Malad, as on the date of publication of the recruitment notification means, Malad, here the notification dated 25 September 2025. If your losses once again, kindly take up that your losses. Page
129.
Much obliged to loss.
No, it is 160. Sorry, 160.
Yes.
160.
স্যার আগের রুলটা কি 6-2 টা আপনি পড়লেন আগের রুলটা?
হ্যাঁ 6
একবার দেখবেন ওটা
6 সাব-রুল 2
it is in variance
ওটা আনঅ্যামেন্ডেড পড়ছি অ্যামেন্ডেডটা পড় ওই 16 এর অ্যামেন্ডেড now your losses will find the CM 60 25th September 2025 and 3 clause qualification B the candidate must have passed now as on the date of publication of the recruitment notifications. Lord, I'm putting a question to myself. What would be except that date? This is the recruitment note. One has to read with this, and that's the judgment of the Supreme Court.
Okay.
And clear loss. No, just a moment. Malad, kindly take up page 162. Malad, this is 19 November 2025 with reference to our notification dated 25th September 2025. It is notified for all concerned that the online applications are from the eligible candidates such and such. But I'm on that, the last paragraph, last date of September 9, 2025. We are Malad today is what? Now Malad, kindly consider the paragraph 15. My first submissions, Malad, the rule of game cannot be changed because once started, process starts. Second, your lordships, on the date of the notification, they are not qualified. One has to possess that. The Supreme Court also says that. And even, Malad, the last date has been specified. I'm not going to that far because last date is to come up. So, Malad, these are my humble submissions. The pair only, Malad, cannot.
No, last date will be applicable. Yes. Since your case is that the date of publication of the advertisement they should possess. So yours is not the case that the last date is to be taken into consideration within which period they have to procure obtain the.
Because on the date of rule says on the date of publication of recruitment notification.
So 15 has two parts. One is date appointed in the advertisement inviting application. So yours is the first case.
Very first one. That's my case. These are my humble submissions.
Now can.
So file the objection in respect of the can.
Dispose of the.
Well, I'm taking your losses leave. If necessary, I will come.
Amended.
Yes, sir. Your can application. Sir, you make your submissions with regard not to the merit of the writ petition right now. what is the locus of these petitioners in the present writ petition, whether they should be impleaded for the interest of justice or not. That we have restrict yourself to that. I will take his submission and thereafter dispose of this application. If it is found that your locus is there and you will make your submission, thereafter you will make your submission again to merit.
My lord, 2018, my lord, 28th June 2018 notification, my lord, has been shown to my lord. But that, my lord, is a starting point from where a digression was made permitting the B.Ed degree holders to participate in the TET examination. But this was not challenged not before our court and in different high courts as well. But the Honorable Rajasthan High Court will not quash the notification. Rajasthan High Court quashed it in 2021. But in 2022, the board will not continued with reliance on the 28th June 2018 notification and permitted the B.Ed degree holders also to pursue TET. This was not challenged before our High Court. Lord, I would take my lord to the two orders not passed, in as much as one of them was passed at the behest of the applicants before my lord, wherein my lord an order was passed, my lord, saying that these my lord TET 2022 my lord would not be valid, my lord, would not be given effect for any recruitment process. But that writ petition is still pending. We are enjoying an interim order. Lord, I take my lord to page 141 of my CAN application.
Yes. Yes.
18th October 2022.
Yes, 18th October.
But the writ petitioners challenged a notification dated 29th September 2022. Lord, I pause here for a moment. This is the notification which continued to rely on the 28th June 2018 notification permitting the B.Ed degree holders to participate in TET examination. The writ petitioners challenged a notification dated September 29, 2022, issued by the West Bengal Board of Primary Education for conducting Teachers Eligibility Test 2022 for classes 1 to 5. Mr. So-and-so, appearing on behalf of the petitioners referring to the said notification to the writ petitioner submits that the eligibility criteria was fixed inter alia on the basis of NCTE notification dated August 25, 2010, read with June 28, 2018, and also read with October 13, 2021. Then council submitted that the said notification dated 28 June 2018 fixing the qualification of candidate having graduation with at least 50% marks and B.Ed stood set aside by the division bench of Rajasthan High Court in civil petition number so and so by its judgment and order dated November 25, 2021. It is also submitted that the said decision of the division bench of Rajasthan High Court is under challenge before the Honorable Supreme Court in SLP number so and so. Mr. So and so submitted that as of now, the said notification dated 28th June 2018 stands set aside by the division bench of Rajasthan High Court, and as such, the intending candidates having the qualification of graduation with at least 50% marks and the B.Ed are not eligible to participate in TET 2022 examination. It is also submitted by Mr. So and so that not relevant. Then Lord kindly not skips over. Lord kindly comes to the next page. The third paragraph starting with the word considering the rival submissions and materials on record. This court makes it clear that all steps taken and to be taken in terms of the said notification dated 29th September 2022 to the writ petition shall abide by the result of the said pending special writ petition before the Honorable Supreme Court. But now this is important, including the fate of intending candidates who are covered by the notification dated 28th June 2018. So the writ petitioners before my lord, their fate, my lord, was aligned to the pending SLP in Devesh Sharma. Now, kindly, my lord, sees. But kindly sees Supreme Court, my lord, held that B.Ed would not be a degree of eligibility for participation in TET examination. Lord, kindly come straight away to yes. Lord, kindly comes straight away to paragraph 34.
Devesh Sharma has been relied on by Mr. Sharma. I don't know. Paragraph tally করবে. Is the reason.
তাই বলে আমি আমারটা দিয়েছি।
Which paragraph?
Well, paragraph 34, my lord, would get at page 36.
Yes.
In our considered opinion, therefore, NCTE was not justified in including B.Ed as a qualification for appointment to the post of primary school teacher level 1, a qualification it had so far consciously kept out of the eligibility requirement. The Rajasthan High Court, by way of the impugned judgment, had rightly struck down the notification dated 28 June 2018 on the following grounds. Lord, I don't read the ground, but pause here for a moment. Lord, this is a notification issued by the NCTE and Lord has application and existence, Lord, pan-India in respect of Lord all appointments. So if this was set aside in Rajasthan, Lord, the West Bengal government, Lord, subsequently could not have, Lord, relied on it and issued a notification. Now, Lord, kindly comes to Lord, page 43. Which is, Lord, a continuation of paragraph 35. Now, kindly sees the third paragraph, a second paragraph starting with the word, the decision. The decision whether to include or exclude B.Ed as a qualification for teachers in primary school is an academic decision, which has to be taken after proper study by the academic body, NCTE, and should be better left to this expert body. But as we have seen, the decision to include B.Ed as a qualification is not an independent decision of NCTE, but was a decision of the central government, and NCTE was simply directed to carry it out, for that being a direction under Section 29 of NCTE Act, a direction NCTE followed. In the present case, and in the larger context of the matter, we cannot see this as a policy decision, but without getting into this argument, even presuming for the sake of argument that the decision taken at the government level to include B.Ed as a qualification for teachers at primary level is a policy decision, we must say that this decision is not correct, as it is contrary to the purpose of the Act. In fact, it goes against the letter and spirit of the fundamental right enshrined in the Constitution under Article 21A. It is against the specific mandate of the Act, which calls for a free, compulsory, and meaningful primary education to the children. By including B.Ed as a qualification for teachers for primary school, the central government has acted against the provisions of the Constitution and the laws. The only logic given by the central government to include B.Ed as a qualification is that it is a higher qualification. This we have already seen is not correct. Under these circumstances, we have no hesitation to say that the notification has rightly been quashed. The decision of the division bench of the Rajasthan High Court has been upheld. Now, Lord, kindly permit me to place that a review, my lord, was filed against this order before the Honorable Supreme Court. আচ্ছা আমার কাছে আছে। Now kindly comes straight to page 7.
Yes.
Some candidates who possess the TET qualification being and recruited having BEd degree, they felt aggrieved because this had the effect of vitiating the very eligibility criteria that they possess. So they sought for a clarification to exempt them from the rigors of the judgment of the Honorable Supreme Court rendered in Devesh Sharma. Kindly sees page 7, the second paragraph starting with the words. In the given facts, we find that the question as to whether the judgment would be prospective or not was not stated by us in the judgment delivered on 11th August 23. Ordinarily, a judgment acts retrospectively unless it is specifically stated to be otherwise. Moreover, this matter has been heard on several occasions and the points urged by the respective parties have been taken note of by us. As it appears that a large number of candidates with BA degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it to be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 2023 shall have prospective operation, but prospective operation of this judgment shall be only for those candidates who are appointed without any qualification or conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of the case which might have been instituted by them, and such candidates were in regular appointment without any disqualification and were appointed in pursuance of a notice of advertisement where BEd was stipulated to be a valid qualification. Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed prior to the date of judgment was delivered on 11th August 23. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. This is very important. So it was only in respect of the in-service candidates,
yes,
that this relaxation was rendered. Now, kindly sees that page 144. This is a notification dated 7th of November 2022. This has reference to the order dated 18th October 2022, which I indicated to my lord at page 141. We said that the fate of those candidates would abide by the result of the SLP. Now, taking a clue from there, board issued a notification of identical nature and put the writ petitioners and like putting candidates at caveat that very well, you may participate, but kindly consider that this all would abide by the result in Devesh Sharma. Now, kindly sees the third line, all steps taken and to be taken in terms of notification, video number so-and-so shall abide by the result of SLP number so-and-so. The BEd candidates applying for TET 22 will be allowed to appear in the test subject to final result. Now, the final result is out. The dicta is here. A review thereof, exempts only those who are in service. I put a question to myself in such view of the fact. The writ petitioners admittedly, they belong to the category who were put on caveat.
They are all BEd.
They are all.
And all the petitioners, the applicants were the petitioners in the earlier writ petition. All of them.
Not all, but as indicated to my lord yesterday. Lord, my lord's query is whether these writ petitioners, my lord,
Not writ petitioners, the applicants of the CAN application was petitioners in the earlier writ petition.
No, we were not. We, my lord, filed the subsequent, my lord, CAN seeking cancellation of their TET certificate. In view of Devesh Sharma's pronouncement, we said kindly cancel the TET certificate of all those who participated in the TET examination with B.Ed as a qualification degree. This writ petition, my lord, was heard by our court, my lord, and kindly comes to page 153.
WPA 10942 of 2025, this is filed by these applicants.
No. This was filed by one HON'BLE Haldar, who was
Now, the petitioners, the applicants herein have filed writ petitions for cancellation of TET 2022.
Yes, that appears at page 153.
No. So this is 2611.
Before, Lord, I place this, Lord, I only say that the first challenge was in HON'BLE Haldar, where the court said that the fate of the B.Ed degree holders, Lord, is aligned to Devesh Sharma. Lord, Devesh Sharma was decided. Now, board issued, Lord, a notification in terms of HON'BLE Haldar's order, putting these people on caveat that your fate is aligned to Devesh Sharma. After Devesh Sharma was pronounced, we said that now cancel the TET degree of these B.Ed degree holders. That certificate.
But I feel I need to intervene because this is all going, Lord, to the merit of the litigation.
No, I have come to my order. Lord, kindly comes to page 153. In this backdrop, now, Milord, Milord came before this honorable court, which is at page 153, order dated 13th of February 2024. But the instant writ petition has been filed by the candidates having regular 2-year DLED qualification, challenging the eligibility criteria of the test conducted by the board in the year 2022 in the said examination process, which was conducted pursuant to a notification dated 29th September 2022. Candidates possessing B.Ed qualification were allowed to participate. The result of this examination has been declared by the board, and the certificates have been issued to the candidates having DLED. We will kindly ignore NIOS. We are not concerned, and B.Ed qualification. The eligibility of B.Ed qualification candidates to participate in TET came to be questioned in HON'BLE Haldar. By an order dated 18th October, a coordinate bench of this court disposed of the writ petition directing board to notify that the entitlement of candidates having B.Ed qualification to take TET examination in first place must be subject to the result of Devesh Sharma. Since Devesh Sharma's supra decision has been pronounced by the Honorable Supreme Court on 11th August 23, the writ petitioners now seek a direction of the board to disqualify all candidates who participated in TET 2022 with B.Ed qualification. By a further decision passed by the Honorable Supreme Court in so-and-so, this is not relevant. In view of the dicta of the Honorable Supreme Court as above, the candidate who either had B.Ed DLED NIOS is not relevant, are not eligible to participate in TET 2022. Now, the grievance of the writ petitioners, stated simply, is that ineligible candidates would eat into the vacant post, thereby depriving the eligible DLED regular post candidates like themselves in the process of recruitment of assistant teacher to be conducted by the board in future. Lord, I pause here for a moment. This is my positive case.
Can you either be
the kindly sees 10, 12. Let no process of recruitment for the post of assistant teacher for TET 2022 candidates with B.Ed qualification under the board be advertised in the meantime. But this writ petition, my lord, is pending. This interim order, my lord, has not been challenged.
Now, what does 12 mean? 12, what is the direction in para 12?
My lord, no process of recruitment for the post of assistant teacher for 2022. My lord, kindly read this as TET 2022.
Why?
Just a second. Candidates with B.Ed qualification under West Bengal Board of Primary Education be advertised in the meantime. So in respect of these B.Ed candidates, whose, my lord, candidature has now become suspect because of the pronouncement in Devesh Sharma, blood, there would be no advertisement for them.
Should I answer the first blood, the applicant's locus, or blood should I argue blood as a whole? The Lordship has heard them.
May I only indicate that one thing? But the issue, my lord, came up for consideration, my lord, insofar as the eligibility, my lord, is concerned, whether this can be relaxed or not. My lord, before the Honorable Chhattisgarh High Court. If my lord pleases to hear me on merits, my lord, later, I shall place it. Then if my lord permits me now, I shall permit.
I will place that because there has traveled to Supreme Court. I will be relying on the Supreme Court. That arising out of that. So I will be placing that. I'll be placing that.
Yes.
But the first question, Lord, which was raised, Lord, I'll conjointly, Lord, I'll reply so far the applicants. Lord, again, the stalling, Lord, Lord, the stalling is a process.
You will get your opportunity to make your further submissions on the merits, right? He will make his submissions with regard to CAN.
Because it's ultimately, Lord,
conjointly,
ultimately, Lord, when I answer, Lord, the questions raised by, Lord, the respondents, including, Lord, the applicants, this covers, Lord, everything, including the whether they are necessary party or not. Lord, your Lordship would kindly appreciate one aspect that everybody has heavily relied on Devesh Sharma. Because everybody's case is that since the notification was struck down, so accordingly, the candidates, the petitioners before your Lordship, they are not allowed to participate in TET. But the answer lies in Devesh Sharma's judgment, Lord. I'll rely on that first also. Lord, your Lordship would kindly take, Lord, আমাদেরটাতে সবাই নালে প্যারাগ্রাফ গুলো আবার গন্ডগোল হয়ে যাবে। Green ভাগ করা আছে। Lord, your Lordship would, everybody has said that it has been set aside, the entire notification has been scrapped and all, but nobody has read, Lord, two paragraphs which, Lord, I am going to place before your Lordship. This first is, Lord, the mean judgment delivered. Your Lordship would, Lord, this was essentially on the point of, Lord, whether this notification of June 2018, Lord, would stand or not, whether this is ultra virus or not, Lord, the Supreme Court has said. I accept that, Lord, it's there. But there are some provisions has been made. The person who has already appeared in TET as well as in the recruitment process. It's not only, Lord, recruitment process, because this was never mentioned before the Honorable Supreme Court that there is a TET procedure has also been concluded. Only the recruited candidate, Lord, they have approached for clarification, that has been taken into consideration. But in other words, it has never been said that the person who has appeared in TET pursuant to the eligibility criteria as mentioned in June 2018 notification, their eligibility has been, cannot be taken into consideration. But I'll point out that
that was the issue in.
No, Lord, it's not that. Lord, this has traveled beyond. Lord, I'll also argue, Lord, before your Lordship, Lord, the principles of, Lord, prospective, Lord, effect of the judgment. Lord, your Lordship would kindly state we take, Lord, page 18, paragraph 80, Lord, the last page, 362. I've also quoted in my writ petition that particular paragraph. May I just read it, Lord? But it says the notification dated such and such is an independent decision and, Lord, gone. Now, having made, the Lordship has got, Lord. Now, having made the above determination, we, all the same, are also of the considered opinion that the state of Rajasthan was clearly in error in not calling the application from B.Ed qualified candidates, for the reasons that till that time, when such an advertisement was issued by the Rajasthan government, B.Ed candidates were included as eligible candidates as per the statutory notification of NCT, which was binding on the Rajasthan government till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed as under. We are of the opinion that the state government could not have ignored the notification while inviting applications for RWT, even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal. The same had to be stayed, set aside by a competent court before it could be ignored. So, my lord, the view of the Honorable Supreme Court while deciding, my lord, the issue with regard to the notification of 18 June 2018, that it was incumbent upon the state as well as the competent authority to ask for application from the B.Ed candidate also. Now, my lord, that was also the view of the Honorable High Court, of the Honorable Rajasthan High Court, that has expressly said. Lord, the next paragraph is also important. Now, my lord, I'll just read, Lord.
Just a minute.
Then may I read further?
Yes.
The next paragraph. What the Rajasthan High Court had stated above is the settled legal position. In the recent judgment of this court in state of Manipur versus Surya Kumar Okram, this position that a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law has been reiterated. So, yes, everybody is saying that since June notification 18 has been scrapped by the Honorable Supreme Court, so you do not have any right. But yes, indeed, I do not have any right. But till it is declared unconstitutional. Your Lordship would kindly see the date of the judgment of Devesh Sharma. This was delivered on 11th August 2023. And I have...
Then in that event, you have to wait for the decision in the other writ petition where
Right.
the order has been passed.
I'll answer those, Lord. So, Lord, this judgment also takes care of the part that the persons who are having, Lord, B.Ed qualification, they should have been called for to participation in the recruitment process. Lord, it's never been pointed out by anybody. These two paragraphs has never been placed before your Lordship. Now, Lord, the date is very relevant because this was in the month August 11, 2013. 2023. Lord, I passed state in the month of February 2023. Three, Lord. The date is, Lord, of 2022, but I have passed. The result was published in the month of February 2022. Lord, I am aware that there is a caution and give notice given to the extent that subject to the result. Lord, result is not against me. Lord, we need to read, Lord, the decisions of the Honorable Supreme Court in conjunctive way. Lord, we cannot exclude that part. Now, Lord, I'll place, Lord, these two paragraphs. Lord, I'm heavily relying on paragraph 80 and 81. Lord, the judgment which has been referred by the Honorable Supreme Court, Lord, with regard to, Lord, prospective reliability, Lord, I'll just place that judgment before your Lordship, Lord. Your Lord, that, Lord, 2022-19 SCC, Lord, 723.
But in the reply, my lord, new judgment cannot.
No, it's not reply. What reply?
Yes, my lord.
Lord, Mr. Biswas has forgotten perhaps. Lord, I said, Lord, the Mr. Shandal did not take the point of, Lord, TET qualification. I said that I'll make, no, Mr. Biswas, please remember. I said that I'll make my submission with regard to TET, Lord, after, Lord, they raise point. Because there are documents, Lord, I'll be placing before your Lordship that they are making a report before this honorable court and submitting otherwise here. Like I have documents, my lord, to that extent. Kindly bear me for a second, Mr.
My lord,
Biswas.
I will get
Take your
also,
seat.
my lord,
Yes,
opportunity,
yes,
my lord, deal with
definitely.
judgment, my lord, because my lord, he is placing
It is placed in the Devesh Kumar's judgment. You had ample opportunity to place this. You suppress that thing.
Give your reply to the CAN application, or otherwise I implead them as a party. Let them make their submissions. Thereafter, you complete.
Lord, the only answer is before your lordship, Lord, is that they have already filed a writ petition, Lord, seeking similar relief. Instead of pursuing the writ petition there,
Okay.
they have.
Asun, we dispose of the CAN application. Implead them. We hear out. Asun. Affidavit of service, affidavit of opposition filed on behalf of the petitioner is taken on record.
Let them come.
This is an application for addition of party. Learned advocate for the applicant submits that the applicants filed a writ petition. Some of the applicants, Ujjal Haldar, some of the applicants were petitioners.
Shilpi Sen, which was dealt by minor justice Mantha.
These applicants have filed a writ petition being WPA 2661 of 2024
So that's the reason I said
challenging the
wise to accept you as a response.
eligibility criteria of the eligibility test state 2022 conducted by West Bengal Board of Primary Education WBBPE in the year 2022. Or 22 to bole dilam, chhede din, full stop. The petitioners in the present writ petition are have claimed themselves to have qualified date 2022. Have claimed themselves to have qualified date 2022, which is challenged in the earlier writ petition. Orders have been passed in the said writ petition to the effect that no process of recruitment for the post of assistant teachers for 2022 candidates with B.Ed qualification be advertised by WBBPE in the meantime. The said writ petition is still pending. The amendment of the NCTE dated 28 June 2018 allowing the candidates with B.Ed degrees to appear in TET examination has been set aside by the Honorable Rajasthan High Court, which has been affirmed by the Honorable Supreme Court. Therefore, the present applicants are necessary party to be impleaded herein. Opposing such prayer of the applicants, Mr. Sabir Ahmed, learned advocate for the opposite parties, submits that the applicants are no way prejudiced by the petitioners, by the prayers made in the writ petition.
And I also say that this is a separate cause of action. They do not have any locus.
Cause of action are distinctly separate. And therefore, addition of parties would be a futile exercise so far as the present litigation is concerned. He seeks for dismissal of the application. Upon going through the materials placed before this court, it is found that these petitioners have challenged the eligibility criteria of TET 2022 conducted by West Bengal Board of Primary Education in WPS 2661 of 2024. 2661 of 2024, which is still pending. There cannot be any dispute that the petitioners claim themselves to have qualified in TET 2022 in the present writ petition. Thus, this court finds that the applicants are necessary party. Accordingly, let the applicants be implemented as a party respondent. Numbers.
The words, Lord.
Lord,
10 to?
Lord, 10 to 15.
Respond number 10 to 15. Added respond numbers 10 to 15 in the present writ petition. Learned advocate for the petitioner is directed to hand over copy of the writ petition along with its annexures to the learned advocate for the added respondents. Kindly. Yes. Can 1 of 2025 stands disposed of?
Then may I continue, Lord, in that event?
Yes.
Then may I continue with that event because Mr. Shanal has substantially argued. Lord, they were present. Lord, yes, Lord. So far, Mr. Shanal's Lord answer is concerned. Lord, they have already all along Lord present here. Lord, they cannot deny Lord because the cutoff date is Lord is hitting soon. Lord, 9th is the date. So Lord, Mr. Shanal's Lord, I
We'll continue tomorrow. We'll continue tomorrow. Go through that writ petition.
Lord, may I?
Lord, kindly keep it tomorrow. I shall come.
Malad, only one prayer, Malad, just Malad, subject to correction. Malad, yesterday Mr. Sanal hand over a Malad copy of the writ petition. Malad, where এক মিনিট আমি অন্য জিনিস বলছি where Malad they were earlier writ petition they were party, but I'm just paying before your lordship Malad. If your lordship Malad hand over the copy of the writ petition, I will make it photocopy and hand over your lordship Malad. But because this is Malad
It's ordered by Justice Bhattacharya.
no Malad the writ petition Malad 10942 of 2025, Malad, which was Malad we relied upon to show your lordship that the present
Some of the petitioners have claimed themselves to be declared as qualified.
Cause of action, Lord. I have.
না আমি ওটা তোমার বলছি না
This one,
just I will make photocopy and hand over to you.
Lord, I have a soft copy, Lord. I give it to Mr. বিশ্বাস.
না আমার এখানে অ্যানেক্সটা আমার
সবই আছে
নেই দাদা
Lord, may I file a supplementary affidavit, Lord, I have already served, Lord, indicating, Lord, these are necessary, Lord, pleadings, indicating that the person who has passed TET 2022, having a qualification B.Ed, has been allowed to fill up the form and participate in the recruitment process in this selection process.
Again, then we have to go back to Mr. Sannal.
No, Lord, I have already supplied a copy. Yesterday, Lord, I have supplied a copy. I have already supplied a copy. It's not that Lord, I'm
press argument and
no.
We are
Ultimately, your lordship would kindly remember that I did not open my mouth with regard to the TET qualification and all. I was about to Lord, make submission.
We have to draw a line.
extend them.
Right.
Correct.
What I am on, Lord.
But every time the pleadings, if it
it's
get
not
changed, then I have to also give them opportunity to refute or otherwise accept whatever.
But your lordship would kindly apprise kindly appreciate one aspect. I was about to make my submission, but Mr. Sannal sitting here said, no, we are not saying anything about it.
No, never said. You said, Malad, whatever we have, we will submit.
This is something, Lord, I need to travel far, Lord, then. Mr. Sannal has said that we did not say anything. Then, Lord, I said, if Mr. Sannal is saying anything about my TET qualification, I reserve right to reply to that extent. Lord, I was about to reply that today. Lord, even if, Lord, subject to the participation of the, Lord, applicants, because the applicants' claim is also to the extent that I do not qualify in TET. So, Lord, if your lordship, Lord, the pleadings which is made in the CRAN application or pleadings in the writ petition is primarily based, Lord, the primary relief is for, Lord, publication of the result, Lord, of my DLED examination and allow me to participate. Now, Lord, so far the second part is concerned, Lord, the applicant who has been newly added in the writ petition, they will definitely make their submission. But the point which raised by Mr. Sannal with regard to my qualification of passing the TET, Lord, I want to answer before your Lordship. Lord, if your Lordship would kindly hear me, because they will also not be prejudiced, because it's not the pleadings that, because we have claimed ourselves to be a TET qualified.
It will be an unending process. Unending process only.
No, it will not
And
be.
my lord, that issue is
Again,
pending
you
before
file
the
a
another
supplementary
bench.
affidavit. He will make his submission. Again, you will file another supplementary affidavit.
Lord, the
Suffice what he has
supplementary
submitted.
affidavit is only annexing
go
one
on and on.
document which I have already given to Mr. Sannal. It's not that I have come up suddenly. These documents were supplied to Mr. Sannal yesterday. It's not that.
Then what he has submitted yesterday, he could have taken a leave yesterday only. But that was not indicated to this court that you are going to file a supplementary affidavit.
But while hearing,
while on the leave of the learned advocate for the petitioner,
so that I can also
He
serve
is
it to the
granted
applicants
to
also.
file supplementary affidavit.
The petition to which?
Supplementary affidavit filed by the petition is taken on record. Copies be served to
yesterday,
and to the added respondents as well.
Everybody. Now, is that application taken here?
Tomorrow to come and list this matter tomorrow.
So, Lord, we'll continue tomorrow, Lord.
Yes.
Lord, may I beseech one thing, subject Lord to kind sanction, Lord. Can he come back at 10:30 tomorrow, so that, Lord, we can conclude, because I find Mr. Majumdar is also joining me tomorrow, because he has also a similar kind of petition. He will also, Lord,
Again, my lord, I'm
advance.
saying, my lord, the factually are different.
No problem. Lord, I'm on the
That I
similar,
proved, my lord.
because
Today,
everybody.
yesterday, my lord, today,
Correct,
factually different.
Factually, everybody is different, but everybody wanted to appear in the recruitment process. So, Lord, Mr. Majumdar is also, Lord, take some time. So that is the reason, Lord, I was beseeching your Lordship, Lord, if this can be given some priority and I can come and argue, Lord, my part.
Court fees have been paid.
Yes, Lord, your Lordship has recorded also that. I've already paid
Tomorrow,
the deficit court.
first hour. Yes, Mr. Biswas, first hour tomorrow.
I have no problem.
Sir?
Yes, dear Lord. Because your Lordship is, my lord, giving us, my lord, so much intelligence, my lord.
No. Once we have started, we have to.
No, my lord.
Come tomorrow.
Indulgence is of mine, because I've come from a different side.
এটা রাখুন। Hello.
তোমাকে বলে কিছু বলতে পারি না।
Sorry, take it down to first 11.
আমার জন্য
আপনি
সবই হচ্ছে আমার
topic.
করে কি
কনস্টিটিউশন আছে।
কালকে হবে, কিন্তু কালকে এটার পরে হবে, কন্টিনিউ ম্যাটারের পরে হবে। ওই তো in today's list, Mr. Majumdar is appearing in which item?
69.
Not in the list, madam.
It will appear tomorrow.
This is supposed to appear tomorrow.
Item 69.
No, aski nahi, Rajkumar.
Mr. That has been fixed, Lord.
Tomorrow.
ठीक.
My lord, item 70 also, my lord, will take up tomorrow or my lord today?
70 is related.
Same matter, my lord, with the 69. Though there is no applicant, no application was.
No. You are ready with that. The other side is ready.
Yes, your lordship.
Who is on the other side?
Madam,
Well,
I'm
court.
opposing, madam.
Okay.
Lordship, my lord, take it up tomorrow, my lord. Today, piecemeal manner, my lord.
Opposing everybody.
I'm opposing everybody.
Opposing everybody.
If you don't find any advocate on the other side, you will ask me to Biswas to appear. Then tomorrow,
10:30, my
after his
lord.
continuing matter, then
কি বলবে 10:30? 10:30. Yes, your lordship.
এবারে এ থেকে ডাকো। Thank you.
Grateful, madam.
Thank you.
My lord, this matter I am appearing for the applicant.
My lord,
What is this application?
I am for the respondent number 6, my lord. I am the erstwhile petitioner where this matter was disposed of as non-prosecuted.
My lord, kindly come to page 20.
So what is this application for?
My lord, this application is for releasing my
Releasing the amount.
Deposited according
Praise the
to
Lord.
the order of the
Call
Honorable Justice Aniruddha Rai. My lord, kindly come to page 20.
for non-prosecution. Page 20.
Page 20. Annexes C1.
Made by the school and already deposited at the report of the report.
We are a government company, my lord. West Bengal Agro Industries Corporation.
Yes. Then
We are the, my lord, I am the added respondent in the matter. Subsequently, my lord, without giving any notice to us, the petition has been withdrawn by the, I have been, my lord,
Another fact
no,
of
it
the
is-
case is that the government has sanctioned about 19 to 20 lakhs amount for the building of a Paka structure of a madrasa. And agro industry is even given the charges. Now, I am in the one of the managing committee. There are other public also. There is a dispute in which plot that should be happened. Due to this application, my petitioner has made a writ petition. So his plot should be taken into priority. In this context, the Honorable this court has directed that the amount which has been settled by the government has to be deposited with the district magistrate unless and
no, my
until
lord, not with the district magistrate.
Not district magistrate, to the
Register
General High Court.
is over. Now the managing committee, both the madrasa, have jointly settled the particular land, and for this reason, I have withdrawn the case, the writ petition for non-prosecution. But the amount which was kept with the register, that has to be disbursed. For
That
this
has to be
reason-
disbursed.
for
That
this
is the
the application has been made. So the madrasa building can be
done.
I beg to appear on behalf of the Madrasa Board. The crux of the matter is that if your lordship may kindly assail the last order passed by it has been specifically stated that a particular the minority department has sanctioned some amount of money for the development of a building. Now, the pertinent question of law, what was raised at that particular point of time, was that the particular land on which the building was supposed to come up, it happens to be in Khas Khotiyan, that is Khotiyan number 1, which is a vested land. And how come a building come up on a vested land? That was the question. And as such, a report was sought from the DI of school, which is yet to be received by this honorable court, until and unless the amount was supposed to be deposited with the registrar of High Court, and which is deposited there. Now, let the matter, your lordship, how can the fund be sanctioned? How can it be released? Because where it has to be ascertained on affidavit where the land has to, where the building has to be constructed. Now, as of now, the building is not constructed. Why the money will be released?
My lord,
And I am the authority. I am the authority which
my lord,
has
money is
under me,
money
under
is
me, under all the
it is public money, and it is our money. It was awarded
dispute
by
the report is rising. That has been settled. The person in whose name this land has been given, he has given that to build the madrasa in his land. That was I heard, and for that reason, this petition has been withdrawn for non-prosecution. I have withdrawn the petition for non because there is a settlement. So make a madrasa. Whether the land has been earlier decided, and the person whose name, he also agreed that in my land that madrasa should be built, and that land was handed over. That's paid. It was handed over to the court also. For this was non-prosecuted.
Matter has already been, my lord,
Which application?
when the
Which
matter
application?
has been
If
disposed
they
of.
are stating that there was two managing committee. First pertinent question of law, that in a madrasa, how can two
Then my lord,
managing
he has
Two
to
managing
file-
committee.
then my
No,
lord, he
there
has
is a
to file
dispute
fresh
between
case.
the managing committee.
Then my lord, he has to file a
Minor-
fresh
Wait,
petition, my
wait,
lord. He has to file a
Let
fresh
him submit, yes.
petition since the matter has been disposed of.
I am the madrasa board. Under my supervision and administration, all the madrasas function under the state of Calcutta. Now there is a madrasa concerned, and that madrasa There was a dispute. The government Bengal has released some fund for construction of a building or for the development of the said madrasa.
Yes.
Now it was during the course of hearing, it was found out that the concerned madrasa was at the concerned building which was to come up. This was coming up on a vested land, Akpot land. So, with the intervention of the court, the money was kept in the registrar of High Court, and thereafter a direction was given to file a report by the DI on what to look into the matter and give a report. And that report is yet to come. So how come Your Honor the money will be released? Because and what my learned friend is harping upon that there were two groups and those two groups have settled which land has to be paid. Now that has to come through an authority. How can you file a report or you take a resolution? File the resolution before the court. There is a system for everything. No such resolution has been filed as on date. Now that has to be approved by the board. Again, everything has to be done. Public money
So
cannot.
as of now, it is to be restored. He has paid for
I am paid for, I am paying for
restoration of the
amount, since the matter has already
My lord,
been disposed.
the dispute between the parties has been settled, and for
That's
this
what-
I have
that is
withdrawn.
there.
I have withdrawn the writ
Why
petition
no
because
resolution?
writ petition has been filed for dispute. Now there is a settlement, and we have withdrawn the
Possibly,
writ petition.
Where is the outcome?
he
What
has-
is the outcome of the settlement?
My
There
lord,
should
he
be a
has
resolution
appeared-
by the managing
My
committee,
lord,
which has to be
He has
affirmed
appeared
by
on
the West Bengal Board of Madrasa Education. Why no such resolution has come up?
My
My
lord,
lord,
since
this
the
was
matter has already been
deposited
Ten
before
one.
the court, and my lord, the last offense for this, the non-prosecution has been made.
my lord.
There is a report has been found that
If they have a dispute, they may file a fresh writ petition, my lord. Not in this writ
cannot
petition.
ask-
Because writ
ask
petition
this
has been
such-
dispute.
ask anything.
If they have the dispute of the madrasa,
And the construction company.
My lord, besides
Why
that,
they are
he was,
supporting the
should I adjourn the matter?
Lordship, no. Yes, Lordship.
There is no necessity.
my lord, on 18/8,
Please wait.
আমি দিয়েছি আমি করছি।
বাকি পিটিশন আছে রিট পিটিশন সেটা তো ডিসকাস হয়ে গেছে এখানে ব্যস্ত
my lord,
Who is for the state?
it is not appearing, my lord. My lord, kindly come to page 25, my lord. Page 25, that is the order.
But
When
this
the
is
matter
not
has-
the first time you have prayed for release of the amount. This is not the first time you are praying for release of the amount.
I have prayed earlier.
Earlier,
Then
but that was not allowed.
No, my lord.
Because
that
there's
was-
a writ
that-
petition is
A
pending.
report
my
was
lord,
not.
that was not allowed.
That time writ
That-
petition is
at that
pending.
time-
Now writ petition has been
My lord, at
disposed
that
of for
time-
No,
non-prosecution.
My
There
lord,
was a paid preliminary report that was submitted by the district magistrate, and the court found that there is no necessity to release a sum which was sanctioned by the state authority.
at that
Block
preliminary matter
development
is
officer
pending.
has also reported. The court says that the issue involved in this dispute needs to be heard finally.
Well, at that time.
But the writ petition has been disposed because the parties have settled this petition.
So much is
My lord,
petition.
my lord,
My
my lord,
it's
kindly
my
come
writ
to
petition, I
page-
can
My
take
lord,
it written back by my lord for non-prosecution. If they have any problem, they have to file a fresh one, my lord. Because we made the writ petition for the dispute and we have settled, and now we have withdrawn the writ petition.
And my lord,
And
kindly
that's
come to
why
page
order is passed.
25. My lord,
Why this was not brought to the notice of the court while the court was while the prayer was made by the petitioner to withdraw this writ petition?
He was
Were present.
He was
I
present.
raised the issue. I raised the issue at that time, but Lordship, it was not heard. Give us.
My lord, I have a
If
copy.
the order dated such and such is recalled, then it has to be restored. So the scan will be kept pending. If you have any objection to the can, so far as the prayer for withdrawal of the amount is concerned, you file your opposition to the affidavit in opposition to the such application. So far as the recall is concerned, we can recall that order and restore the writ petition to decide the issue finally.
But my lord, writ petition is filed by me. We have taken
There
proceedings.
cannot be an adjustment between the agro industry and the petitioner.
No, not
there
a-
cannot be an
between the parties.
I have
Private
government
misconduct and
Vested land, you
My lord, I
cannot,
have
you cannot make construction on vested land.
No, my
That
lord,
report has been filed by the block government company.
the government company, I have known the minority affairs. The Department of Minority Affairs awarded that to me.
This is an
The
application for a recall of order dated 18th August 2025. By order dated 18th August 2025, along with a prayer for release of an amount of rupees 2059,756 together with interest in favor of respondent number 10 is agro.
Yes, my lord.
Respondent number 10.
I have already responded.
Added respondent number 10, West Bengal Agro Industries Corporation Limited. Learned advocate for your Madrasa board. Madrasa board, Mr. Nadeem Sulaiman, learned advocate for Madrasa board, submits that as per the report of the block development officer, block land and land reforms officer, Itahar Uttar Dinajpur, the land in question is a vested land. Upon perusal of such report, this honorable court on 21st March 2025 directed the issue to be decided and heard finally. However, in the meantime, the petitioner sought for withdrawal of the writ petition, which was allowed. So far as
without serving me any copy.
So far as the recalling of the order dated 18th August 2025 is concerned, he does not raise any objection. However, he submits that the prayer for release of the amount of 2059
My lord,
756
that has not been, my lord, no notice was given to us.
is to be heard and decided finally. In view of the above, the order dated 18th August 2025 is recalled. The writ petition can 2 and 3 has been disposed of.
And earlier can has disposed.
আপনার আমার 1 and 4
না না can কত
can 4
can 4 2 and 3 disposed of.
Petition is restored to its being number WPA 21506 of 2022 is restored to its original file and number. Do you intend to file any opposition to the application?
No, my lord, because we have withdrawn. Whatever.
Madrasa board respondent number. Madrasa is respondent number.
Lordship, we are respondent number 3.
Respondent number 3. West Bengal Board of Madrasa Education is directed to file affidavit in opposition to the application within a period of 2 weeks. We reply the if any filed one after 3 weeks under the heading application.
My lord, kindly noted that we have paid for the withdrawn of the writ petition early.
That has been recorded.
My lord.
No.
I'm grateful. Item 3.
My lord, I am for the petition, my lord. Restoration application, my lord. Order dated 27 February 2025.
Affidavit to serve.
My lord, my learned friend is appearing.
I'm for the state respondent, my lord.
This is my service, my lord.
Sued against. কি দিল এগুলো? এটা contempt?
My lord, paragraph 4 and 5 I stated, my lord, the reason for not.
The affidavit of service?
My lord, letter handed over. My learned friend is appearing.
The advocate for the petition seeks accommodation to file affidavit of service. Let such affidavit be service on the returnable date. Leaves this matter after 1 week. File an affidavit of service.
This is a contempt application, my lord.
Yes.
By order dated 12th of September, my lord's pleasure was to issue rule
Yes.
directing the contemner to appear personally
Yes.
on 6th of November 2025.
Yes.
But I have instructions that pursuant to the rule, my lord, the contemner was present in court, but my lord, the honorable court was not available on such day. My lord, today, my lord, really kindly pardon us, my lord, she is available online. This is from Bakura, my lord. Yesterday night, my lord, I could bring notice of this matter appearing today. She is appearing virtually. My lord, coming to the merits of the matter, my lord, will kindly come to page 21, the order impugned. The directions are contained in order dated 28th of March 2025, which is at page 19 of the contempt application. Page 19 of the contempt application, my lord, will kindly come to. Here, my lord, illegal construction is, my lord, was alleged of, and my lord, will kindly come to page 21, the directions of this honorable court, my lord.
Page 19.
19. At page 21 are the directions, my lord, will kindly come to page 21.
21.
Clause 1, I, these are the directions. But we are to, the BLRO concern was to cause an inquiry. Thereafter, after hearing both sides, my lord, the Pradhan is to pass a reasoned order. My lord, unfortunately, my lord, with deepest of humility and unconditional apology, my lord, I say this, my lord, this inspection report was not available to us. We have got hold of the inspection report. Really kindly, my lord, give us some time, my lord, for compliance. My lord, we are to hear both the parties in terms of clause 2, my lord, and pass a reasoned order in terms of clause 3. May I very humbly pray for 3 weeks time after vacation, my lord.
For the petitioner.
My lord, no one is appearing, my lord. I find, my lord, Boidurro Ghoshal was appearing for the petitioner.
Okay. On 6th you appeared.
My lord, 6th I appeared, my lord. I have records to show that I have taken, my lord, gate pass from the High Court, my lord. And my lord, since the court was not available, my lord, the usual course is, of course, my lord, to note appearance before the Registrar General. My lord, these litigants, my lord, did not know, my lord, I have the gate pass showing that I have come, my lord, and other records, of course, my lord, showing that I have come to this court, my lord. May I very humbly pray for some time for compliance, my lord, and come.
On behalf of the petitioner, the sole contemner is represented. Mr. Nilotpal Chatterjee, learned advocate appearing for the sole contemner, submits that on the returnable date fixed on 6 November 2020 by 2 p.m., the sole contemner appeared before the court. However, since the court was not seen, the appearance of the sole contemner could not be noted. He also indicates that since what is the inquiry report?
The inspection report.
Since the inspection report was not with the Pradhan, the further steps could not be taken in accordance with the order passed by this court on 28th March 2025. He seeks 3 weeks accommodation to comply the order of this court. Please this matter 3 সপ্তাহ করে ডেট বলুন। 5th January. 5th January.
Lord, kindly take note of the virtual appearance of the
sole contemner appears on virtual mode. Next, sole contemner is directed to remain present on the returnable date.
I'm grateful, Milord. We are grateful, Milord.
Yes.
I beg to appear on behalf of the Madrasa Board.
I am for the petitioner.
What is the interim order?
This matter relates to the even extension of the interim order, which was passed 1 minute.
आगे उन्होंने बोलते था
Which was passed on 21st June 2024. 21st June 2024.
21st June.
Thereafter, subsequently, it was extended time to time.
21st June
2024. I have got a copy of the order.
Extension was till
30th of November, you know.
30th November, no extension application made. Today the interim order has expired. It cannot be extended.
Lordship, the extension order expired on 30th November. No CAN application as of now has been made by the petitioner, and moreover, your Lordship, the board has in the garb of extension every time. They are not interested in they are not they don't have any intention, or rather valid intention, to proceed with the matter. Just they are taking in seeking.
When
your Lordship,
order was passed,
and your Lordship, I am equipped with the
So
order. I am equipped with the order of the board, which was passed on the first day of December. So on the first day of December, there were no such interim order, because it has already lost its validity on 30th of November, and by way of which we have already appointed an administrator. Now the situation is so grave, your Lordship, the situation is so grave. बोलते दिन आगे. The situation is so grave.
The appointment of the administrator was stayed by the Honorable High Court. Kindly see this order.
That stay has expired on 30th.
On 30th. Fresh though. This is the fresh application.
Fresh one.
And so it has already lost.
One submission.
I submitted
This cannot go for endless time.
This is endless. 2060.
Administrator, the government authority has been appointed as the administrator.
Your
matter was mentioned. It is for my
Your Lordship may see that generally a DI of school is
or SI.
a DI of school.
Nothing is there.
Who will submit?
Let him finish.
Are you here to apprise the court or fight amongst yourselves?
I am for the petition. I have to make submission first.
Yes, make your submissions on 30th November. It has expired. Now you are seeking for extension of the interim order. no application has been filed for extension.
Lordship. I mentioned this matter because the issue is was taking your lordship determination because your lordship was not available. Now the matter was fixed on last Friday, but unfortunately his lordship is not sitting. He is not sitting. Now last Friday, Sunday is the 30th November. Immediately on Monday, I mentioned your lordship. Stating to that extent, this is the situation, my lord. This bench was not sitting. I could not extend this interim order. But the last, I mentioned to your lordship, taking a step back. Your lordship acknowledge, you can give this a little bit listed under the heading extension. But I have got no pause because the Friday this was fixed. Now his lordship is not sitting. Now I know Saturday, Sunday. Now Monday I mentioned this matter before lordship.
Monday.
Got no
Mentioning sleep to kotha first December, correct? We'll reinstate that. What order have you passed?
Lordship.
So you are waiting for this to be done.
Lordship. I'll praise the court. Yeah. Lordship, let him.
There was an order of this court for one day, that 30th November, it expired. What prompted the authority to pass an order so hurriedly?
Lordship, this extension, this madrasa, 2013, it was given the last extension, and the extension of managing
Sir,
committee.
an order passed by
Lordship,
this court.
Lordship, I bowed down before you. Lordship, may kindly be a patient here.
The knowledge of the board that there is an order, but one day, for any reason, that was not extended.
So
that doesn't mean that you take the opportunity and pass an order appointing an administrator.
Lordship, I come to this
when
point.
The legality and validity
Lordship,
has been
I come to this
by this court and an interim order has been.
I'll answer to your Lordship. Lordship, there is a proper way of coming up with an application. So, as my learned friend was harping upon that, he had mentioned it before, Honorable Justice Biswajit Basu. So, he was supposed to come up with an application, supply an application to me. He never even bothered to supply an application today. As my learned first submission, that it was mentioned on Monday. Monday also, no such copy was supplied to me. So, my intentions are, if in the absence of any copy, Your Lordship, he is taking the, he is demonstrating before the court. He had ample opportunity. Order is passed that, see, I have not appointed any DI nor the ADI. How grave the situation is that I was compelled to appoint an BDO.
2 times
SDO.
was stayed. 2 times.
I had to, it was under sheer compulsion because their high-handedness. Their high-handedness has gone up so much that the DI or the ADI, they are not able to handle the issue.
2 times the administrator was said by this court.
2016, Your Lordship, their tenure has expired.
Stayed by this court. In spite of that,
I by this management.
I appoint them.
And even the apex court, even the Supreme Court in 2025 had dismissed their application, Your Lordship. On the second paragraph of first page, the second paragraph, Your Lordship may find the same. And he was...
This point was raised. In spite of that, 4 times interim order was extended.
This endless and undue.
Their extension cannot go on for an endless time of time.
Then let the Madrasa Education decide. If the court is extending the order and you say that it is endless, so we start on 1st December. Since it has expired on 30th November,
Your Lordship, kindly paragraph 2
cannot be allowed.
Your Lordship, kindly peruse paragraph 2, Your Lordship. The apex court has also thrown away the application, Your Lordship.
Aware of an order, interim order being passed, and there is a delay of 1 or 2 days. He mentioned on 1st December. Now I grant him liberty to file an application and set aside this order. If you have any grievance, you place your grievance before the court that such and such circumstances has been created. So we have to be given a liberty to appoint somebody
Your Lordship,
else.
it is because of that we are objecting, Your Lordship.
But objecting does not mean you pass an order. When you are yourself aware that there is an interim order.
Your Lordship is there to look into. If I've rightly, if I have passed any order, Your Lordship may set aside this order. But Your Lordship, this cannot go on for end period of time, Your Lordship.
At last, my lord, that
On the prayer of learned
Your
advocate.
Lordship.
teacher in charge of the school. I am not being allowed to enter into the school. I am not being.
This is the
Teacher in charge. I am in the records. Today, the management whose term has expired in way back in 2016 is running a school illegally.
And the secretary single-handedly running the school, Your Lordship. And the paramount of the students' interest should be paramount. The interest of the managing committee has become paramount over here.
Interim order. কিছু করা যাবে না, this is the interim order was granted on 21st June 2024.
Your Lordship, we are calling them to the office of the board. They are not coming up. We are asking for the account. They are not giving the account. There are a lot of anomalies, Your Lordship. They are recruiting teachers illegally. They are throwing away. They are not. The TIC was there. They are not allowing the TIC to enter into the premises. He is the TIC. He is not allowed to enter into the school, Your Lordship.
My lord. The management committee whose term has expired as on 2016 is now illegally running the school.
June
এবার my lord দেখতে দাও যা rightly wrongly আমরা যা ventilate করে দিয়েছি we have
You have filed an opposition?
No, Your Lordship.
Why?
Order was order ছিল না আমার মনে হয় না কোনো order ছিল না সেরকম opposition এ
An educational institution is suffering every day.
Education institute
21st June 2024. The said interim order was extended from time to time and lastly extended on 31st July 2025 till 30th November 2025 and extended till 30th November 2025. The matter was mentioned for extension on the subsequent date, that is 1st December 2025. Since the earlier interim order was not extended after 30th November, an order has been passed by the Secretary on 1st December 2025. Appointing whom?
Appoint the last page, Your Lordship, first paragraph, last page, first paragraph. The SDO. The SDO.
Appointing the subdivisional officer Kontai Purbo Medinipur as the administrator of Kontai Rahmania High Madrasa. There is also an interim order passed in the other writ petition.
Yeah. In other writ petition also, this managing committee will continue. Kindly see the order.
কোন order ভাই?
Kindly see the order.
কোন order?
কি বললাম?
কোন order?
Yeah, the managing committee will continue. There are two writ petitions pending.
In view of the circumstances
Lordship, my submissions
as
may be
enumerated above, yes.
My submissions may be recorded, Your Lordship. My submissions may be recorded, Your Lordship.
Learned advocate for the petitioner seeks for reinstatement of the interim order and extension. Opposing such prayer for extension, Mr. Nadeem Sulaiman, learned advocate representing the Madrasa Board, submits that there is the functions of the madrasa is getting hampered,
Lordship,
day by day due to non-appointment of an administrator, and at the same time high-handedness of the managing committee.
Lordship.
The order which has prompted the Secretary, West Bengal Board of Madrasa Education to pass such an order for appointing the administrator, Subdivisional Officer Kontai Purbo Mednipur as the administrator of the said madrasa. There is palpable non-cooperation on the part of the managing committee in administration of the madrasa. You are representing Mr. Ghosh?
The teacher in charge, my lord.
No. Teacher in charge,
Huh?
1 minute.
No, no.
Teacher, in fact, teacher in charge has been removed.
No, I have not been removed. I have not been removed.
Now, I have.
Your respond.
Pending.
Your respondent number?
No,
Your respondent number.
Your respondent number. তুমি respondent number কত?
He's not the.
Man, I am.
My record
teacher in
shows
charge.
that he is the teacher in charge.
Has been
Teacher in charge.
Lordship.
But the respond number?
I being the state, I am adopting submission of Mr. Suleiman without.
Mr. So and so.
The respond number 6, my lord.
Suhinde.
Sumonde, man.
Sumande.
Shumonde, learned advocate for the state, adopts the submissions advanced on behalf of Madrasa Board. Sir, you are a respondent herein.
He is respondent number 6.
6, my lord.
Mr. Sono Ghosh.
No, I am the teacher in charge.
Mr. Sono Ghosh. Sir, is he respond number 6 in your writ petition?
This is new teacher in charge.
Again, my
He is not there. Mr. Sono Ghosh for respond number 6 also opposes the prayer for extension of the interim order. It is found that the interim order was valid till 30th November 2025. On 1st December 2025, the matter was mentioned before this court for extension, and accordingly the same has been listed and taken up today. In the meantime, an order has been passed by the Secretary, West Bengal Madrasa Board, appointing the Subdivisional Officer Kontai Purbo Mednipur as the administrator of the said. Taking into consideration the inter circumstances, the appointment of the Subdivisional Officer by the Secretary of West Bengal Board of Madrasa Education dated 1st December 2025 is set aside. The interim order is reinstated and extended for a period of 4 weeks or until further order, whichever is earlier. 4 weeks. So there was no such direction to file affidavit in opposition.
No, your lordship. কামে কোথায় affidavit file করেছে চলো। তুমি দেখে নাও না। তুমি দেখ আচ্ছা ঠিক আছে তুমি দেখিয়ে দাও।
Affidavit has been filed by the.
হ্যাঁ reply we have filed your lordship. Affidavit
reply কি করবে?
Affidavit reply কি করবে?
Affidavit file করছে কি বলতে পারো?
না affidavit কোথা দেখো আমার affidavit
21st June 2024.
Brief দেখবে না কি?
এই একদম দাও।
And extended for a period of 6 weeks.
ঠিক আছে।
Was there any direction to file affidavit in opposition?
Lordship, we have already filed affidavit.
Acha. Extended. List this matter after issue of the 3 weeks করলে কোথায় যায় January.
Lordship, but date may be fixed.
January তে করো। January 2nd week.
A date may
be fixed, your lordship.
So that it can be finally.
It can be finally decided, your lordship. Our school is suffering since last 16 years, your lordship.
But only one thing, 2 matters were appearing analogously. And may I just hand
Kobhe
the previous order? The other matter may be also tagged with.
হ্যাঁ বলে দাও বলে দাও বলে বলে
Second week এ দাও।
ওই আদার ম্যাটার গুলো ট্যাগ করতে বলো।
আরো কি মানডে মাদ্রাসা আমাদের? না
12 তারিখ ছুটি।
14th মাদ্রাসা ডেট বুধবার তো 14th.
Lordship.
But a connected matter was appearing, might need to appear along with this writ petition on the urgent date, my lord.
With this, all these are related.
These are all related matters, your lordship.
May I hand
Of the same madrasa?
Lordship.
Same madrasa.
There is a checkered history, your lordship. They have 8.
No. This is the same madrasa.
Same madrasa, your lordship.
Same madrasa.
You know, ওটা ওই দিন দিয়ে দেবে। Affidavit and opposition have been filed. Affidavits have been filed in that.
তোমার
Take instruction.
14 January ঠিক আছে?
After matter, I have to take instruction.
Consecutive with করবেন না consecutively.
ঠিকই আছে।
চলিয়ে। Thank you, sir.
We are grateful, your lordship.
Yes.
I'm praying for short pass over. My senior is engaged in court number 30.
14. Yeah.
On behalf of Rajnir Mukherjee, not this speaker, due to his marriage, he is unable to.
The prayer of learned advocate for the petitioner. Please this matter after 2 weeks. 2 weeks. Well,
Item 7, no, item number 8, my lord, appeal for the petitioner. Two of the first up. Oh, I thought. The issue is, my lord, very simple, my lord. Initially, I was appointed as an organizing teaching staff in a madrasa, my lord. Subsequently, my appointment has been approved by the DI, my lord, in terms of an order passed by this honorable court. That order was moved up to the division bench, my lord. State preferred an appeal. That appeal was also dismissed, my lord. Kindly come to page 20. That was the appeal preferred by the state challenging the order, wherein an order was passed approving my appointment as organizing teaching staff, my lord.
As a
organizing teaching staff. My kindly come to my approval on page 16. No. Page 16 is my approval. In compliance of I prefer an content application, my lord.
Of appointment in favor of Muhammad Yasin as a this is recorded. Okay.
What has been complied with, my lord? There was mentioned, my lord, that subject to result of the appeal dismissed. So this order has attained its finality, my lord. Issued and the approval was granted, my lord, since, my lord, 30th of July 2024 in terms of the order passed by this honorable court, my lord. The issue is that, my lord,
state. Okay. Yes.
My lord, a bill has been raised for a period from 30th of July 2014, my lord, up till 31st of December 2025, amounting to 3,96,000 something, my lord. That was still pending before the Director of Madrasa Education because, my lord, DA has no function. So for my information is concerned, my lord, DA has no function. DA has no fund, my lord, to release the area salary, my lord. It has to be sanctioned from the Director of Madrasa Education, my lord. DI has sent the proposal to sanction the amount.
Where is that?
At page 21, my lord, last annexure. DME has not till date, my lord, DME has not sanctioned any fund to enable the DI, my lord, to disburse the area salary in favor of me. It was sent, my lord, by the DI to the Director of Madrasa.
I already contact, but I have no report. Please give me a 7 days.
Only simple issue, my lord, payment of area salary.
My lord, I already contact. Give me a 7 days, my lord.
Next week.
Next week.
Any day. An order, ma'am.
Please kindly pass.
Service filed on behalf of the petition is taken on record. Learned advocate for the petitioner, Mr. Swenso, learned advocate for the petitioner, submits that pursuant to order passed by this court.
My lord, page
in WPA
Is 13, my lord. 1-3.
WP 16866W of 2007. The petitioner was absorbed and granted approval.
Page 16, my lord.
Appointment as a past graduate teacher with effect from 30th July 2014, which was subjected to result of appeal being MAT 1897 of 2014. This said appeal has been dismissed on 2nd December 2015. By the present writ petition, the petitioner claims for arrear salary from 30th July 2014 till
31st December 2015.
31st December 2015. The matter is still pending with the department for disbursement of the amount of arrear of salary. Arrear salary. So and so learned advocate appearing for state seeks an accommodation to file report. Leaves this matter next Wednesday. 10th.
রিপোর্ট ছাড়া আমি কি করে করবো? আমি তো জানি না, জানি না কি হয়েছে, ডিসবার্সমেন্ট হয়ে যেতে পারে, ক্লিয়ার হয়ে যেতে পারে, হ্যাঁ আমি সবটাই শুনে নি। গ্রেটফুল মাই লর্ড।
Your lordship fixed for further hearing
next 10th.
My obliged, deputy obliged. 10 তারিখ।
10th. Sujit Gupta, he is my senior. Okay.
Item 9.
As per the petitioner, my lord, read by Mr. Sudipto Dasgupta, he is engaged before court number 11, my lord. Kindly adjourn, my lord.
What is the prayer?
My lord, kindly adjourn, my lord. He is engaged before court number 11, my lord. 1 day, not 2 days.
দু সপ্তাহ পর on the prayer learned advocate for the petitioner is this matter after 2 weeks.
Lord, on 12th November, it was heard by a Lord. That matter was the payment of higher scale of pay on the basis of the master degree. The DI has rejected the lack of prior permission. So my lord has been on at the time of passing the order, my lord wanting to know the petitioner has completed the part 1 examination prior to his join as an assistant teacher.
Oh yes.
That documents my lord want to see. My lord, I have prepared my lord the supplementary affidavit, my lord.
Who was appearing for the state?
My lord, the Supriyo Chattopadhyay, he appeared earlier occasion also. He, my lord, admitted the petitioner is entitled. My lord, I am placing the case. My lord, kindly come to the order of the Honorable Court. My lord, kindly come to page 40, my lord. What order was passed earlier occasion to the directing the DI to consider the case. Page starts from 38. My lord, the relevant page, my lord, 40. হ্যাঁ ফোন করো ঠিক আছে হ্যাঁ ছিল ডাকো my lord page 40 my lord got it my lord
page 40
judgment also decided those who have completed prior to his join in the partly, they are entitled to get, they are the honors category, so they are entitled to get the master degree my lord, skill. So my lord, page 40 my lord, it have third paragraph.
It appears that the petitioner was appointed on the post of assistant teacher. My lord, got it, my lord? In a government-aided high madrasa and initially was concerned honors graduate scale of pay. At the time of joining of the petitioner, he completed part one and subsequently part 2 of English postgraduate course from the Badon University in the year 2010. Since the petitioner at the time of joining was possessing honors graduate qualification as was sanctioned honors graduate scale of pay, therefore, in terms of section 14(3) of the West Bengal Schools Control of Expenditure Act 2005, he is entitled to receive the postgraduate scale of pay in a manner as may be specified by order. Considering the facts and of the present case, since the petitioner was undergoing a higher course of studies at the time of joining the post of assistant teacher in the madrasa and subsequently completed the said course, the ratio of the judgment, the judgment will consider the division bench judgment. Here, my lord, the no, for a larger estate. This is the quoted the division bench decision, my lord. The last paragraph, in view of the above discussion and placing the reliance of the judgment of the Honorable Division by Adiluzzaman, this could direct the district school AC Birbhum to consider the prayer of the higher scale of pay of the petitioner, but it has been clarified that since the ratio of Adiluzzaman Supra applies in the case of petitioner, it would not be open to the concerned DI of schools to reject the prayer of higher scale of pay on the ground of lack of prior permission. So, my lord, here, my lord, court directed specifically that cannot be rejected the application for granting higher scale of pay the lack of prior permission. Kindly, my lord, the DI what did, my lord, kindly next page, my lord, page 43. On the last paragraph, my lord, last but one paragraph. The undersigned is an implementing the officer, my lord, got it, my lord, of the government policy, act, rule and order. It is beyond his power to go beyond the government policy and order and rule and order. In the matter, the petitioner government order has been violated as per government memo, government order. He is not eligible for higher scale of pay enhancement of his qualification, but the honorable court holds that the prior permission from the district school is concerned is not required. So, consider the entire matter to decide by the case of the higher scale of pay is referred to the matter of the director. So, my lord, here, my lord, the court specifically directed not to take that, my lord, he is again, my lord, there is the lack of prior permission. Even, my lord, the larger bench also, he, my lord, the completed the, my lord, he has joined in the year 2009. He, as a honors category, in a, my lord, aided madrasa. Prior to his join, he has completed the part 1 examination, my lord, which was completed on, my lord, kept to supplementary affidavit. Part 1 examination completed, my lord, start from, my lord, the page 5, my lord, start, my lord, the examination was started on 24 June 2009 and completed on 4th July 2009. Page 6. It has been certified by the, my lord, the control of examination. My lord, the supplementary affidavit.
My lord, Mr. Supriyo Chattopadhyay, learned LG, my lord, is my lord, dealing with this, my lord, applying for the state, my lord, but he is not, my lord, doing well, my lord, for last few days, my lord. He has come, but not feeling well, and he is about to leave or already left.
Junior,
no, even I assist him in some matters, but he is not doing well for some days. COPD problem, breathing trouble, all these things. If it is not so urgent, the next time.
Since it is pending, my lord, one thing, my lord, whether he is ill, my lord, I am not opposing. But since he is pending since 2024, so my lord, only one day, my lord, is taking madrasa. So let him, my lord, the next Wednesday, my lord, so the same position it will remain in.
For the prayer of learned advocate for the petitioner, leave is granted to file supplementary affidavit.
Or my lord, let it appears to be mentioned as your lordship.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Give a copy to him. Copy, sir. Learned advocate for the state 6 accommodation. Please, this man. Finish. এটা নিন এটা
না অসুস্থ বলছে সেখানে না দেবে জসে আগের দিনে অর্ডার দিচ্ছে সেটা কথা না ও অসুস্থ সেম পজিশন মানে
সিম্পল টু ক্লিয়ারলি উপরের দিকে ঢুকে দিন
Item 11 and 12, my lord, both are
ওটা কি চলে গেছে
the same petitioner, my lord. The item 12 may be taken up first, my lord.
7318.
My lord, 7318.
Where is your reply to 7318?
My lord, the writ petition was filed, my lord, since I was recommended for the post of superintendent. But since due to the criminal proceedings was pending, I was not permitted to join, my lord. My lord, this honorable court by an order dated 17th February 2023, my lord, directed the director of the DME, my lord, director of Madrasa Education, to take a decision whether the petitioner can be permitted to join, my lord. But pursuant to the direction, my lord, the DME has already passed recent order, which is a part of the FAU in opposition, which has been filed by the respondent number 9 and 10, my lord, page 14, my lord. My prayer has been rejected. But this order needs to be challenged, my lord. But the liberty may be granted, my lord, to challenge the petition, this recent order by a petition, my lord.
You will withdraw this?
Yes, my lord, with the liberty to challenge the recent order passed by the director of Madrasa Education.
Which matter?
12. 7318.
And what of 9240?
My lord, it is, my lord, the still cause of action is there. My lord.
Please call over. The petition was recommended for appointment as a headmaster in my school. While he was acting, he was also acting as an assistant. We issued a letter before the Mother Service Commission that we could not issue any appointment in favor of Anushu Rahman as the headmaster of our institution because certain criminal allegations we have received from certain angles. And thereafter, my lord, the rules states that if any school authority or madrasa authority does not want to issue the appointment letter or he receives any, my lord, having certain objections, my lord, against the recommendation, that should be informed before the Mother Service Commission. And Mother Service Commission, after receiving that, my lord, objection, the entire matter should have been remanded to the director of Mother Service Education for taking a decision, my lord. But in terms of, my lord, we have placed the entire issue, my lord, before this honorable court, and after hearing, my lord, the argument of all the parties, my lord, the entire matter was relegated before the director of Mother Education for taking a decision. Now, director of Mother Education has already taken a decision that until and unless he received a acquittal order from the learned court below, he should not be allowed to be appointed as a headmaster of our institution. So this is a, my lord, and director of the passed an order, my lord. If any, my lord, if the petition is agreed by that order, he should come before the honorable court by challenging it.
Yes, I'm praying that liberty before my lord.
That is fresh cause of it. That is
9240.
9240 is a cause of action is there.
What is 9240?
9240, my lord, I have been placed under suspension, my lord. 9240 to party name. But since, my lord, 18 January 2024, my lord, page 19, and under the under the 2002 rule, my lord, 28 rule of 2002, my lord, but the suspension cannot continue beyond 90 days, my lord. Therefore, I was praying, my lord, since, my lord, the board is the approving authority, my lord, let the board take a decision whether, my lord, the suspension order should continue or it can be, my lord, the revoked.
বোর্ড একটা অ্যাপ্রুভাল দেবে আর স্কুলের মতো ঠিক আছে
7318 টা কোথায়?
Item 12.
Item number 12. কোন রুল দিচ্ছ
28. হ্যাঁ, এখানে তোমরা বলছো যে 90 days এর পরে পারবে না।
Learned advocate for the petitioner submit that during the pendency of the writ petition, which is the order?
My lord, it is a part of the FAU in opposition filed by the respondent number 9 and 10, my lord. Page 14, my lord. Order dated, my lord, 11th August 2023. পারবে না।
এখানে আছে
The order to give writ This order passed by Justice Basu in which writ petition?
My lord, in 7318. My lord, order
7318.
dated, my lord, 17 February 2023.
Submit that pursuant to order passed in the writ petition on 17 February 2023. The OSD and ex officio director of Madrasa Education West Bengal has passed order that the prayer of the petitioner
90
for allowing him to join as superintendent in Shirsi IM Senior Madrasa Uttar Dinajpur has been rejected. The petitioner intends to withdraw this writ petition with a liberty to file a press challenging the order dated 11th August 2023. Learned advocate for the respondents leaves the matter to the discretion of the court. In view of the above submissions advanced on behalf of the petitioner, the writ petition being number WP 7318 of 2022 stands dismissed as withdrawn with liberty to file a press.
Great.
9420 টা একটা order করে দিন, আলাদা করে order করবেন।
I don't stand in the way.
What is the stage in 9420? Affidavits have been filed.
No, my lord, it is still as the motion stage, my lord.
Motion stage.
My lord, page 19 is the order of suspension.
ওটাতে আছে না?
Dated, my lord, 18 January 2024, my lord.
উইথড্র যেটা হয়ে গেল 9240 এই তো। ওগুলো ছিল কোনটা?
9240 এটাকে 2 সপ্তাহ পর on the prayer learned advocate for the petitioner place the matter after 2 weeks. So 9240 I am adjourning it for a period of 2 weeks. Let it appear under the heading motion. In the meantime, if you file any writ petition, okay.
But the suspension order, my lord, let the board take a call, my lord. Or let the board file a report, my lord, whether they want to.
Any report has been filed? No.
Sponsor my lord, and I think for the school also, the same school matter. But I have not received any copy of the request.
The advocate for the petition is directed to the copy of the writ petition along with its annexes to respond number.
Is respondent number 9, teacher in charge.
Respond number 9.
Yes, sir, yes, sir.
Hey, teacher in charge, respondent number 9.
Respond number 9. No, 7. Respond number
Secretary 7.
7, my lord.
I am, that is respond number 7.
789.
789.
789. Respond number 789. Do you intend to file any affidavit in opposition?
The requisition first, my lord, and fixed a date.
And what about you?
Lordship, as he's stating that section 20, rule 27, P, sub rule I, which says that any dispute regarding that suspension, it may be referred to the board and the board may take the final decision within, if it is not filed within 90 days. So the law says so. So I shall not stand in the way if anything falls from your lordship. So if your lordship can send it to the board for a recommendation, then
Upon hearing the petition as well as the madrasa.
Upon waiving a due hearing upon all the parties.
This kind of order, my lord,
My contention, but
At this stage, you are not filing any affidavit nor any report.
No, your lordship, because I don't.
If it sticks to the point of law, that can be decided by.
Decided. So we
Sir,
I don't want to stand in the way.
Service করে নিয়ে list this matter after 2 weeks under the same heading.
Great.
আর এটা appeal করবে dismissed হয়ে গেল
Great. 12th.
May I please your lordship, my lord, by filing affidavit of service showing service upon all the respondents. For the case of the petitioner, my lord, is that her husband was an assistant teacher. My lord, he was serving in the school. Subsequently, my lord, during his service period, he expired. Leaving the petitioner as widow and others. My lord, he opted for, my lord, DPF scheme by switching over from the CPF. Thereafter, that was, my lord, not allowed by the authority, and the order which was passed by this honorable court at page 27 started. Operative portion, my lord, page 29, middle portion. In those circumstances, I am reading, my lord. Page 29, your lord.
Communicated within a period of 1 month. Date of
I hereby directed to communicate to the petitioner within a period of 1 month on the date of receipt of a copy of the order, the amount of provident fund to be credited to the account of the government along with interest in terms of the notification issued by the government dated June 30, 2014. That order was communicated to the concerned authority. During that period, no steps have been taken by the authority concerned. In the meantime, lockdown period came. My lord, the petitioner could not file any application under the content of Courts Act. It has been stated, my lord, paragraph 7, page 8. My lord, that I am just praying before your lords, directing the authority to implement the order passed by the honorable court.
Again, an order for implementation of that order.
My lord, order. Implementation and or enforcement is no bar.
No contempt filed.
That, my lord, paragraph 17. Paragraph 17, my lord, page 8.
This order has been communicated.
My lord, content application could not be filed aside the prayer is made for implementation and for enforcement of the earlier. That order was communicated. I have annexed with this.
What was the time period given? One month.
And the order was communicated that it will appear at page 35. Earlier order. No steps taken. My prayer is specifically.
And for the state, my lord, the answering respondent is not here.
I have served upon all the respondents. They have been delivered.
Answering respondents is the
Director of Madrasa, respondent 2.
Respondent number 2, 3, and 5. They may be directed to implement the order passed by this court earlier.
And district inspector of schools? District, he is representing district.
No,
District inspector of schools? You are representing?
I am representing the state only.
None appears.
Number 5 is the authority, my lord. Will transmit all the papers and then communicate.
Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for implementation of the order passed by this court in WP number 14265W of 2019. The petitioner contains that her husband, her husband late Abdur Rahman, was an assistant teacher of Dohikod Bari Asrafia High Madrasa who died in harness while in service. He was in died in harness on 12 June 2000, leaving behind the petitioner and others as his legal heirs.
Died in harness.
While in service, no?
12, 6,
98 এ ও ইয়ে দিয়ে দিল, অপশন দিয়েছে না?
98 এ দিয়েছে।
তো
The
Option in the
husband of the petitioner duly opted for the General Provident Fund with pension scheme. However, the family pension was not granted in favor of the petitioner. The petitioner filed a writ petition before this court, being WP number 17716W of 14265W 2019. The said writ petition was disposed of page 29 দাগ দিয়ে দিল। Since passing of the order, no steps have been taken. Hence this writ petition. Mr. Sujit Kumar Roth, learned advocate for the petitioner, seeks for appropriate direction upon the respondents concerned to act in terms of the previous order of disposed of a date 10th December 2019. State is represented. The learned advocate for the state leaves the matter to the discretion of the court. Despite service, none appears on behalf of the respondent number, who were directed 3.
Director of Madrasa
Yes.
and Director of Pension.
2, 3, and 5. 2, 3, and 5.
Director of Pension he is representing and District Inspector of School he is representing. Only 2. Director of Madrasa.
Despite service, none appears on behalf of respondent number 2, Director of Madrasa. In view of the above, the writ petition is disposed of, directing respondent numbers 2, 3, and 5 to take steps in terms of the order of this court passed on 10th December 2019 in WP number 14265 W of 2019 within a period of 1 month from date of communication of this order. The advocate for the petitioner is directed to communicate this order. Dispose.
I appear on behalf of the petitioner, my lord.
My lord, item 14, my lord, Mr. Supriya Chattopadhyay is appearing on behalf of state, my lord.
14
14.
state কোনটা কোনটা 8954 এই তো ওই রিনা খাতুন না 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 না, কোথায় আছে মানে এতদিন হিয়ারিং হয়েছে তুমি আমার মনে হয় ভুল করছো না না একটু ভুল হয়েছে না না, ভুল হয়েছে আমি না 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 এই মামলা
My lord, with review of the court, may I be permitted to file a supplementary affidavit as because the same health matter on
জানি এটা কি
challenging that challenging the termination and on another application is being filed before which is pending before the law. And I have said that enter a supplementary affidavit where the state government they have filed a short report in page number
কি মামলা? No, my lord, first of all, my lord, I am to understand, my lord, your lordship is allowing filing of supplementary affidavit.
I don't know.
My lord,
Yes.
my learned friend is relying on a document which he has not served because your lordship, my lord, he has to take permission from your lordship for filing any supplementary affidavit.
Yes.
First of all, the writ petition, he is addressing your lordship on the basis of a supplementary affidavit. Let my learned senior friend, my lord, address your lordship on the merit of the writ petition.
What is in the writ petition?
Yes.
that is the thing.
My writ petition is this, that a fake certificate has been given by the respondent number 6. And that's why the medical authority, they are the selection. That's why in my writ petition, I sought for addition of the party in supplementary affidavit on page.
No.
না এইটাই তো হবে না
No, my lord, on the last occasion, when your lordship has heard the matter, there is no dispute that the certificate obtained by the private respondent is disputed. But my learned senior friend has sought for a declaration, and your lordship prima facie made an observation that this court may not be in a position to declare that the certificate is forged. So for that, you have to approach the appropriate forum. That was the observation made by your lordship in the last hearing.
Okay.
That is the prayer in mandamus, prayer A.
তাই তো হ্যাঁ হ্যাঁ ঠিক আর
Allegation against me. I
Oh,
have
acha,
appear
এই
with
তো,
all the
এই তো।
documents.
Then my lord,
With my genuine documents, I am filing the supplementary affidavit, like enclosing all the certificate which has been challenging my learned senior friend before this honorable court.
তুমি আজকে appear করছো?
ভালো হয়েছে খুবই ভালো
Affidavit কি ফাইল করে দিয়েছে? You have filed your opposition?
No, in made each application, I have not filed any opposition.
Filed your opposition?
Yes.
Why supplementary?
Then
Whatever you have to oppose, you oppose.
my lord.
As you know.
You have filed your opposition.
lordship nothing is against me your lordship because
My lord, the state need not file any affidavit in opposition
All
to
the
this
allegations is
petition.
against 6.
Yes, my lord.
Against me.
against respondent number 6
But they have also lost the criminal cases, or all criminal cases are going to be false. Against this challenging the marks.
That is a sub judice in the court below. I do not know whether that is false or not. That is sub judice. That is
Honorable court has to decide such issue. This is the jurisdiction reach of judicial has no the possibility of this declaration of the certificate.
It cannot be.
হ্যাঁ এটা ঠিক কথা
A is not maintainable.
This is the rich court. Rich court has no scope to declare the whether it is correct on a disputed question of fact.
By the present writ take it back, not required. By the present writ petition, the petitioner seeks for declaration that the mark sheet issued by respondent number 6 is fake, false and fabricated. The petitioner contains that the past Madhyamik examination from West Bengal Council of Robindro Open Schooling in the year 2008.
No. This is
subject to correction
my lord, this is madrasa education.
madras
He has stated in para 2.
Paragraph 2 যা বলেছে তো আমরা কিছু করতে পারবো না
No, Madhyamik, yes, but my lord, he is disputing the certificates issued by the West Bengal Board of Madrasa Education, if I have understood.
Which paragraph this has been stated?
My lord, page 26 of the writ petition. Lordship kindly sees once.
I have clearly stated.
I am sending here a Xerox copy of the mark sheet of High Madrasa Examination 2013 under West Bengal Board of Madrasa Education issued in favor of the private respondent has been appointed. So he is disputing the High Madrasa Examination 2013 certificate issued by the West Bengal Board of Madrasa Education. Right?
একদম ঠিক আছে তুমি ঠিক আছে
Yes.
When you are there, I need not assist. হয়ে গেল
in which my lord petitioner made a right to information act where the madrasa as well as where they appeared in the case, and they have specifically stated that the petition respondent number did not appear in the pool or some.
Lordship will find my reply at page 25, your lordship, annexure P7, which specifically states that does not tally as per office record.
Yes.
So as it was asked for, we have replied the same. As we are not the issuing authority, we cannot declare that it was a fake certificate, right?
Page 24 and 25 specifically madrasa board
Fake mark sheet কি issue করবে? I myself is issuing a fake mark sheet, তাই না?
রবীন্দ্র ইউনিভার্সিটি ঢুকে গেল
আপনি
না আমরা
234
হ্যাঁ 234 আপনি ঠিক আছে
Now, what is the order passed in 19th November 2023 by Additional Mission Director?
That is a termination letter, my lord. That was challenged in another writ application. That is in subject.
Where is that order?
That is WPA 12 of 2024.
Where is the order dated 19th November 2023 passed by Additional Mission Director? কি বললাম
19th November.
She passed.
Well, there is an order cancellation that appears from page 19 of the writ petition, that is 10th of November 2023.
Page
The
20?
cancel, yes, page
20.
19, my lord,
19.
of the writ petition. Cancellation and approval of candidature for Asha under NHM. That is in respect of the writ petitioner. This is not under challenge in this writ petition.
No, the mark sheet is challenged.
Yes, mark sheet is under challenge.
Petitioner contains that petitioner passed Madhyamik examination from such and such in the year 2008, and she was appointed as accredited social health activist Asha at Anantakota subcaste under Nauda Gram Panchayat, Hemtabad block, district Uttar Dinajpur.
The termination letter in my writ application in page P4,
18.
page 18.
Oh,
হ্যাঁ 18 নম্বর পাতা আছে
25/11.
The petitioner service was terminated. Petitioner's service was terminated by appointing respondent number 6, who claimed herself to be qualified in the selection test for ASHA workers. The petitioner sought information under the Right to Information Act addressed to respondent number 5 as to whether respondent number 6 had appeared as an external student or not.
My reply, Your Lordship, will find at page
In
25.
reply, it has been informed that the respondent number 6 did not sit for High Madrasa External Test Exam 2012. The records of the board pertaining to respondent number 6 of her mark sheet and documents does not tally with the board records. On such basis, this writ petition has been filed seeking for declaring the mark sheet of respondent number 6 as fake and fabricated. 1. Learned advocates representing the respective respondents as well as respondent number 6, including respondent number 6, submits that the prayer for declaration is not maintainable before a writ court. They seek for dismissal of the writ petition. There cannot be any quarrel, that the prayer has sought for declaring the mark sheet of respondent number 6 as fake, false and fabricated cannot be pressed into service before the writ court. Such declaration is to be sought before the appropriate civil court having jurisdiction. In view of the above, the writ petition falls short of merit. Accordingly, WPA number 8954 of 2020 and dismissed.
Madam, my lord, I pay for leave to gather this face application.
That is always there.
Yes.
Well, grateful.
At this post. অনেক দিন ধরে চলছে।
Well, I have heard the petition. But payment of interest on the area. What happened, my lord? Director of Pension and Provident Fund and Prevention filed appeal, papered an appeal, my lord. That appeal was pending.
Appeal is pending.
That appeal was pending. Is appearing combined list item number 53 in the division list. So, my lord, from the timing go out the list.
Learned advocate for the petitioner submits that the appeal, what is raised in the appeal? What is the question raised in the appeal?
Area pension appeal take Mr. Janafa.
Person from CPF to GPA, area pension received after some times. They claim for interest on the delay payment of area pension after depositing the government. Single bench will be directed to 8% interest from the date of judgment in Abdul Ghani, whereby the area pension should be released. State government prepared an appeal.
Oh.
Only interest on area pension.
But then in other matters, this interest on area pension is with
different. So this is my lord, after conversion from CPF to DPA, he got retirement firstly from the date of refund, subsequently from the date of retirement.
Yes.
From the date of retirement, which areas were due, that was paid after 2 or 3 years. That is the other matters not related.
Submits that an appeal has been preferred by the state as to whether interest on delayed payment of arrear should be allowed. He seeks that the matter be made go out of list for the time being, with liberty to mention. In view of the above, let the matter go out of list.
Grateful. No, and for the state.
For the petition. Delayed payment of gratuity on single month. Petition retired manner on 30th August 2020.
আপনার সঙ্গে আমি সিদ্ধার্থ ঘোষ সিং।
Months. PPO was issued. That was 5th of November 20.
Oh.
Pension has been given effect from which date?
The date of retirement manner. That is 1st of September 2023. But
Yes.
pension payment order was issued after 14 months.
Okay. Yes.
My lord, may I hand over a copy of the similar order, my lord, passed by another bench, my lord, of this honorable court, my lord.
Affidavit of service filed on behalf. Yes, sir.
Lordship, date of retirement 31st August 2023. PPO was issued 5/11/2024.
That is after
On-
14 months.
This is arrear or interest, no? Interest.
Yes, my lord, no area. Single pension, single PPO.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for interest on delayed payment of gratuity from the date following the date of retirement till the date of actual payment. The petitioner contends that the petitioner was a headmaster of
High Madrasa.
High Madrasa no, the headmaster of Kamur Dayar NH High Madrasa, the police station Domkol district Murshidabad, and he superannuated and retired from service on 31st August 2023. The pension payment order was issued on 5th November 2024. After a lapse of 14 months. The petitioner seeks for interest on gratuity from the date following the date of retirement till the date of actual payment. Learned advocate for the state leaves the matter to the discretion of the court. It is now settled that the petitioner is entitled to interest on delayed payment of gratuity since the pension payment order has been issued after 14 months. Stop. In view of the above, the respondent number, treasury officer, and which are the others? Director of pension. Respondent number 2, Director of Pension Provident Fund and Group Insurance. And respondent number 3, Treasury Officer, is directed to pay interest at the rate of 8% per annum on the gratuity from the in favor of the petitioner from the date following the date of retirement till the date of actual payment. The payment of the aforesaid amount shall be made within a period of 6 weeks from date of communication of this order. Learned advocate for the petitioner directed to communicate this order to respondent number 2 and respondent number 3. With the aforesaid direction, the petition being number WP such and such stands disposed of. Is it? আচ্ছা এটা কত নম্বর না না এটা কোনটা ধরাল এখন কোনটা দাঁড়িয়ে আছে সবই
আসুন
Number 17.
17, my lord, I am for the petition.
But I am for the respondent was 6, my lord.
Beg to appear on behalf of the Madrasa Board, my lord.
My lord, direction of the honorable coordinate bench, my lord, we have prepared, my lord, our opinion opposition, my lord, that maybe
This is my reply to the affidavit in opposition filed by the respondent number 4.
Hello, this is I am for appearing on behalf of state. I am filing my affidavit in opposition.
affidavit in opposition filed by respondent number 4.
I am for the state, my lord.
I am for the respondent
Four.
of 6, my lord. Teacher in charge.
4.
6, my lord.
6. Who is 4?
I am for, my lord. I am for the state.
Affidavit in opposition filed on behalf of state respondent number 4 is taken on record.
6.
And also my 6.
Affidavit in reply on behalf of the petitioner to the affidavit in opposition of respondent number 4 is also taken on record. Affidavit, you're not filing any reply to his 6? No reply?
My lord, certainly. My lord, I have to file a reply, lordship. আগে দিলে তো করে দিতাম তাই না আগে দিলে কি করবেন
Affidavit in opposition
long back order was passed
filed by respondent number 6 is taken on record, copy served. ওগুলোতে copy served. So, learned advocate for the petitioner seeks accommodation to file affidavit in reply to the affidavit in opposition of respondent number 6. Let such affidavit in reply be filed within a period of 1 week. 1 week, sir?
এক সপ্তাহ হবে দুদিনে করে
In the period of 2 weeks, this matter after 2 weeks under
2 weeks.
the heading. Yeah. You are not filing any report or
lots of
not required.
not required দরকার কি আছে বলুন কি দরকার নেই ফালতু ফালতু করে আজকেই তো ডিসপোজ হ্যাঁ আজকেই ডিসপোজ না রিপ্লাই করুক
You will be arguing this case today. You will not file any reply to respondent.
This is depend upon the judgment passed by this honorable court on the same issue.
Okay.
Which I have also in the earlier bench.
Are you be filing any reply to his opposition to respondent number 6?
Or what he has written. But I have to go through.
ঠিক আছে, after 2 weeks let it come up. You file your reply, go through that.
Matter to appear on.
After 2 weeks this will appear. 6 টা double.
Item number 6.
Grateful lords. 6 না এটা করে দিই
My lord, I'm appearing on behalf of the respondent number 7. I'm praying for not today, my lord.
7.
Yes, ma'am.
What is the function of them? You have filed your opposition. 7, you file your opposition. There is a quarter. There is no respondent number 7.
File respondent.
No, main
Yes.
petition में 7 है. Main petition. यहाँ पे 7.
Item number 6.
6. Oh, I'm busy 8. Oh,
Sorry, this is 6.
I'm sorry, my lord.
You are appearing for?
I am for the petitioner, my lord. This is my affidavit in reply I have observed upon the respondents also. They have served me the copy of the opposition, my lord, whether it has been filed before the your lordship have
13th June. Affidavit in reply filed on behalf of the petitioner is to the affidavit in opposition of respondent number 3 is taken on record. Who is for the state?
earlier occasion Ratul Biswas and Biswaposto Masumali appeared. One for the state, one for the madrasa.
None appears on behalf of the state. For answer justice, the matter is adjourned. Release this matter. Next week কি রাখবো? কি মোশনই আসছে না? থাক মোশনই থাক। নেক্সট উইকে রেখে দিন নাকি তারপরের সপ্তাহে? After 2 weeks. Learned advocate for the petition to communicate this order to learned advocate for respondent state. Who is respondent number 3? Respondent number 3 is district inspectors. So state district inspector school is under the state. Kindly give a notice. This will be listed after 2 weeks. Oh. Ratul.
Lordship, my senior, Mr. Vimal Kumar Shahi, he's for the state. Lordship, I'm praying for not today as my senior is engaged with some other matter in different court.
The matter was taken up by your lordship on the earlier occasion. One issue is that whether the administrator has got any power to frame any internal committee. On the earlier occasion, your lordship direct the Nadim Chairman to produce the law. The power has been given. He find out, he did not find out anything. Now he made the submission, say, I will take this instruction. Now let him say whether the committee has got the power to frame any internal committee.
No, the
Administrator.
Sorry,
whether the administrator has got any power.
Sorry, administrator.
At the outset, at the outset, whenever, what is the function of the administrator? Now, the administrators is a stopgap measure. Now, in the absence of any managing committee, or if the managing committee terms expires, the administrator is used as a stopgap measure. Now, the administrator takes over the functions of the managing committee. This is the plain and simple language which is used. I'll draw your lordship's kind attention, and may I read the same for your lordship.
This is what manual is this? This book is? মাদ্রাসার তো কিছু নেই আমাদের বই নামটা দেখে নি লাইব্রেরি থেকে নিয়ে আসুন What is this
madrasa madrasa headmaster's manual নালে শুনুন না আপনার বলছি হেডমাস্টার্স ম্যানুয়াল আছে না তার দেখবেন পার্ট 2 এর মধ্যে এটা আছে হ্যাঁ
দেখো এই যে ভলিউম 2 এই higher secondary council. দেখো নাকি দেখো
কনস্টিটিউশন অফ ম্যানেজিং কমিটি জানা তোমার বইটা কি দাও?
ও তাহলে এটা হবে না, নতুন একটা আনাতে হবে।
না, নতুন লেখা।
ওকে।
ইন্ডেক্স বললে হবে না, match করবে না।
781.
Lordship, Constitution of Management Committee, Rule 8.
This is, which section is this?
Lordship, it is Rule 8.
Rule
Power
8.
of board to approve and supersede the committee.
This is West Bengal Board of Madrasa Education Act.
Lordship. Constitution of Managing Committee.
Constitution of Committees.
Lordship.
Okay.
Rule 8, Your Lordship. I'm placing this for Your Lordship, Rule 8.
This is section 18.
8.
No. দেখাও না একটু ওনাকে, দেখো তো এটা কনস্টিটিউশন অফ বোর্ডস।
আমার বইটাই দিয়ে দিই, অত ইয়ে লাভ বই না
কেন মিললো না? এটা কি?
Lordship, Rule 8, Your Lordship, it is marked with the marker, Your Lordship.
Yes.
The headline. First, I'll draw Your Lordship's kind attention to the headline. Power of the board to approve and supersede the committee. Now, the word supersede the committee, then it means to include that whenever the board steps in by administrator, it supersedes the committee. So automatically, the term itself goes on to say that the power of the managing committee will all be vested upon the administrator. Now, it is further defined. Lordship, I'll draw your Lordship's attention to 8.
কোন রুলটা?
अरे रूल 8 को मैंने ये तुम्हारा एडमिनिस्ट्रेटर अपॉइंटमेंट रूल सब रूल 3 on supersession of the committee.
Yes.
On supersession of the committee or an expiry of the term of the committee, the board shall appoint an administrator. Now, over here, the board has appointed an administrator or an ad hoc committee to exercise the powers and perform the functions of the committee. Now, it has been clearly specified that the administrator has been vested with all the functions of the committee, of the managing committee. So there was a managing committee which was functioning. The board has appointed an administrator, and the administrator has been vested with all the powers of the managing committee until a new managing committee has been approved. And my lord,
No, where is the power of the committee to form an ad hoc committee?
Power of, now, your lordship, this is a stopgap measure. Now, in the absence of any managing committee, who will be into the helm of the affair of the school, for functioning of the school? Anything related to the teachers' grievances or anything related to the grievances of the students whatsoever, regarding the running of the schools, regarding the funds and management of all these things. Now, who will be above the headmaster? There has to be check and balance. That the headmaster needs to be checked whether he's performing, discharging his duty in an efficient way or not. And the teachers, they have been discharging. Now, what by way of this committee, what has been done? There were 2 committees made by the administrator. One committee consisted of the other teachers to submit a report in lieu of the headmaster, and the headmaster, he was enshrined with the job to give a report to the in respect of the other teachers. So So it was again a check and balance procedure, so that the headmaster, he is the head of the institution. He may not be biased in regards to the other teachers, and the other teachers may not be other teachers. So it is a committee of teachers. If I appoint one person, so he may be biased or may not be. If there is a group of teachers, those teachers may submit a report against the headmaster whether he is discharging his duty properly or not. This was the thing to be ascertained. And now why he is standing in the way, and when the law goes on to say that the administrator has been vested with all the powers, and what duty was assigned to the committees? The duties was to just place before whether they are discharging their duties properly or not. So how can we say this is against the law?
My lord, what my lord is submitting?
My lord, I am for the.
What you have read in section 8,
Lordship.
there is no reflection in section 8
Lordship.
that the administrator is vested with the power to form an ad hoc committee.
Lordship, the managing committee.
See, upon expiry of a particular committee, the power lies with the board. Two options. Either you go for appointment of an arbitrator or an ad hoc committee.
Lordship.
It is a power of the board,
Board.
not of the administrator.
That is simply a delegated legislation, your lordship.
How can
I'm
it be?
delegating my power to the administrator.
If suppose a power has been given to the administrator, can the administrator, my question is, can the administrator function as a board?
No, your lordship.
Then, when a delegated power is given to somebody, you act in accordance with such and such. There has to be limitation and restriction. The administrators cannot step into the shoes of board.
Lordship, never.
So board has been given an option, either you appoint an arbitrator or an ad hoc committee. Here is a case where the administrator has appointed an ad hoc committee.
Not an ad hoc committee, your lordship. I beg to differ, your lordship. It is not an ad hoc committee, your lordship. It is just a committee to look into the fact-finding committee. Not the ad hoc committee to run an institution, to discharge the duties on behalf of the, just an committee to submit a report.
Internal committee.
No, three-man committee. Page 3. Page 3, kindly have a look into read petition.
It is not against.
This is a, my lord, this is not a permanent perpetual committee on the strength of the statute. On the strength of the statute, this is not a permanent perpetual committee. With due respect, I am submitting. One complaint was lodged. Please allow me. One complaint was lodged against the headmaster. My lord, administrator, when managing committee, absent administrator is the managing committee. Administrator form a fact-finding committee. That fact-finding committee not pass any order, no decision. Only fact, whether you are absent or not.
Moreover, your lordship,
for that reason, this is the, my lord, attendance sheet. Only fact finding, no decision making committee. This is not a decision making committee.
Where the administrator is wrong, in fact, consisting of, moreover, your lordship may kindly bear with me for a minute, your lordship. Subclause 3.
এটা একটু জাসেফকে দেবেন তো attendance register
subrule 3 subrule 3
absent for the last 2 years, but fact finding you will do the 3-man committee, not ad hoc committee.
It is not a perpetual committee, your lordship.
3-man committee for fact, whether fact is right or wrong.
That, yes.
No decision making committee.
So the statute.
I am statute press.
Not required.
Yes, your lordship may bear with me.
If my lord form 1-2 committee, whether pond is filled up or not, any statute is required.
No, there are provisions where you send a special officer to find out.
Yes.
That job has been entrusted to the special
but no decision making committee. No decision making, only
that
fact
officer of the
whether
court cannot decide
or not.
That is just a fact finding committee, your lordship.
No, what prevented the administrator to himself inquire into the fact?
He is entrusted with a lot of job because he
there are 3 or 4 qualities.
Where is the function of the administrator in this particular?
Yeah, coming to your lordship. Subrule 3, your lordship. I'll place it again, your lordship. I'll place it again. The language itself. On supersession of the committee or expiry of the term of the committee, the board shall appoint an administrator. The board shall appoint an administrator and ad hoc committees. So the board has been given with an option either to appoint an ad hoc committee or to appoint a administrator. For what? For what? To exercise the power and perform the functions of the committee. So the administrator itself is saying the administrator has got every power to function as a committee, as if it is a committee or an ad hoc committee. Suppose now X is ruling over a state. Now X goes away, B comes in. B will be vested with all the powers of X. In the time stopgap measure, the Z is appointed. So Z will discharge all the functions of the committee itself.
Okay.
With due respect, I am
Lordship, this is my innocuous submission, Your Lordship, and this is my humble submission is that this is my plain and simple understanding that the administrator definitely can discharge all the functions of a committee. The plain and simple reading of the rule goes on. This is my humble understanding, Your Lordship.
My lord, administration here in the instant case, administrator page 3, my lord, respondent number 6. Who is administrator? Sub-inspector of school. He is a public servant, my lord, not a political person.
Your Lord.
And my lord, this public servant has many jobs. There are 2 or 3 administrators. Now it has no, my lord, managing committee. All are administrators. So administrators form a fact-finding committee, not decision-making committee. Decision will, my lord, decided by the administrator. Let me make my submission. Yes. What my learned is submitting? Rule 8. Again, I am reading rule 8. Rule 8 that the administrator on supervision of the committee of the committee, the board shall appoint an administrator ad hoc committee to exercise the power and control of the functions of the committee. Now, can you see the functions of the committee? Rule 27 is submitting that what functions of the committee? I am reading. In the area of madrasa, the committee shall have the power subject to the permission of the granted scheme, a revision scheme, or any other order, direction, or guideline issued by the government of West Bengal or director in connection therewith, to appoint teacher on permanent basis, to appoint in accordance with the direction given by the director, to appoint in accordance with the direction given by the director in this behalf teachers and other. In any unaided matter, the committee shall subject to the approval of the board to appoint teachers and other employees on permanent or temporary basis. In all cases, appointment both permanent and temporary, the committee shall issue the rate of appointment. So, what is the provision to form the internal committee or fact-finding committee? If the administrator is functioning as like as the managing committee, then what is the functions of the committee to form the fact-finding committee? Because the letter was issued, page 18, can you see? And this here? Direction for forming a committee and submitting the needed documents. I am directing that a committee be formed comprising Muhammad Manirul Islam, Rafiq Akhtar, Abdul Samad Sheikh. The committee is directed to calculate all the absence. But kindly see, administrator will not do, committee will do, or will take the absence of all the teachers. 1 minute. Of the headmasters of Margram High Madrasa, Ghulam Muhammad, and it is also directed to submit the absence statement and all absent related to the documents of the headmaster to the administrator or Margram High Madrasa by such and such. And the headmaster is directed to submit all leave register and teacher's attendance book to the committee. But I fail to understand. He is the fact-finding administrator will not do anything. He has been appointed by the board. Now he has got no power to form the fact-finding committee. He has given a direction to submit all leave register and all absence statement before the fact-finding committee. Now I am putting question to myself whether the power has been conferred upon you to form that committee and to direct the teachers to submit all documents before the fact-finding committee. What power? What is the power? And there is no delegation power to the
হ্যাঁ
extent.
ঠিক আছে বলে দাও
দাঁড়াও না ওনার সাবমিশনটা বলতে
And that's why, my lord, this entire formation of the committee is illegal. Because administrator have got no power. And a committee comprising three teacher will give the direction. You submit register, will give the headmaster. You are the subordinate teacher. You are the member of the fact-finding committee formed by the administrator. You are giving a direction. You submit or leave register.
ego problem.
This is not ego problem.
Yeah, obviously.
That's why my lord short question: what is the power conferred upon the administrator to form a committee, and the committee will direct to produce or leave register of absent statement?
The nomenclature itself, administration means he may administer everything. The nomenclature itself goes on to say so. And if your lordship may direct anyone to means be the fact-finding committee. If anything falls from your lordship, then that may be accepted, because this kind of discrepancy has to be unearthed.
Administrator, what the administrator do?
He was not in school. That fact
For
remains.
1.5 years.
1.5 years he was not in school. The headmaster himself.
And ego problem.
That is why he's come ventilating over here.
And for that reason, judicial time,
এটা ঠিক, encroaching the judicial time.
Encroaching the judicial time.
Without doing any election.
Hello.
1.5 year absent.
So absent, how can you do the election? Election কি করে করবে তুমি?
By the present writ petition, the petitioner seeks for setting aside and or setting aside / cancellation and or withdrawal of the impugned letter dated 13 June 2025 issued by the administrator, Sub-Inspector of Schools, Rampura East Circle, within bracket annexure P2. The petitioner contains that চাপিয়ে দিয়ে আবার অন্য জায়গায় The content that the administrator was appointed on 2nd July 2024 by the Secretary, West Bengal Board of Madrasa Education. The administrator is functioning over administrative affairs of madrasa. However, the administrator, without discharging his function, delegated power to a committee to calculate the absence of headmaster of Morgram High Madrasa and submit absence statement and all documents relating to the headmaster to the administrator. Being aggrieved and dissatisfied with such action on the part of the administrator, the petitioner has preferred the present writ petition. Mr. So-and-so, learned advocate for the petitioner, submits that the administrator has to act in accordance with the powers as provided in the, this is West Bengal Board of,
Lordship, it is Constitution of Managing Committee.
this falls under which act? West Bengal Board.
The West Bengal Board of Madrasa Education Act 1994.
West Bengal Board of Madrasa Education Act 1994. And therefore, the action taken by the administrator in forming a internal committee is illegal and arbitrary. He seeks for setting aside of the state impugned letter dated 13 June 2025. Mr. Nadim Sulaiman, learned advocate appearing for the Madrasa Board, submits that the committee formed by the administrator is an internal committee and has been directed to inquire the absence of the headmaster. The action of the administrator is a check and balance for smooth running of the administration of the madrasa. The headmaster concerned is absenting from his service in school for the last 1.5 years, which is affecting the functioning of the school as a whole. Referring to Section 8 of West Bengal Madrasa Education Act 1994, he submits that the administrator has all the powers of the committee till a committee is formed in accordance with law. Therefore, such action for smooth running of administration taken by the administrator cannot be called in question. He seeks for dismissal of the writ petition. Mr. Uday Shankar Chattopadhyay, learned advocate appearing for respondent number 7. He is private respondent.
No, 3-man committee, private respondent. That committee made a party.
Oh, 3 members of the committee. Comma, 3-man committee also submits in the similar fashion as submitted by Mr. Sulaiman, learned advocate for Madrasa Board. Having heard the learned advocates for respective parties, the only issue which falls for consideration is whether the administrator by the impugned letter was empowered to form such committee or not. In order to examine the aforesaid question, it would be apposite to reproduce Section 8 subsection 3, which provides that on supersession of a committee or an expiry of the term of a committee, the board shall appoint an administrator or an ad hoc committee to exercise the powers and perform the functions of the committee. Therefore, the administrator, by dint of such provision, upon appointment is bestowed with the powers and functions of the committee. Section 27 provides for the power and functions of the committee. Upon bare reading of the aforesaid provision, it appears that there are no such powers.
Those are the rules, Your Lordship.
Rules, as sections gulo rules kore din. There are no such powers given to the committee for forming an internal committee to find and inquire of any facts. Therefore, it appears that the formation of such a committee by the impugned letter dated 13 June 2024 is not made in accordance with law. In view of the above, the letter dated 13 June 2025 issued by the 2024, yes. 4 years, 4 or 5? 25? 25. Issued by the administrator /
Annex P2, Lordship.
देखे नहीं है बनी है
In 2025.
2025
Page 18, Annex P2.
25 Sub Inspector of Schools Rampurhat East Circle Morgram Birbhum is set aside. The writ petition being WP number 14950 of 2025 is allowed and disposed of. All connected applications and disposed of.
For the interest of the institution, my lord, Lordship, one rider. Otherwise, my lord.
So for the interest of the institution, the administrator has been appointed.
Yeah, great. Great to you, Lord.
Yes.
I'm for a petitioner with particular appearing, my lord.
Yes.
My lord, duly qualified candidate, my lord, and applied for physical science post, my lord, in Madrasa. But my lord, in the meantime, my lord, the pension petition, my lord, their panel have been prepared. My panel, my lord, we are kindly give me 2 weeks time, my lord, to file the apparent affidavit, including all documents, my lord.
But what about the affidavit of service on the other side?
Not yet prepared, my lord. Go ahead.
You file the affidavit, serve this writ petition. Thereafter, we'll see.
Two have been served, two have not been received. So I did not prepare my.
The advocate for the petitioner seeks accommodation to file affidavit of service. Let such affidavit of service be filed on the returnable date. List this matter after 1 week.
Can I fix a date, my lord?
Yes.
Fix a date, my lord.
1 week is coming up on Wednesday.
Yes.
We have service commission.
I didn't receive it.
Receive it?
Yes.
But we have not received any copy from the commission.
I know. Give a copy. And the other respondents?
Board, my lord.
Board. Who is appearing for the board?
Actually, my lord, I am
Suleiman
is a relevant party, my lord.
Okay. So you give a copy? Out of the change code, no?
Don't make my
Learned advocate for learned advocate for Madrasa Service Commission submits that the copy has not yet been served. Learned advocate for the petitioner hands over a copy of the writ petition along with its annexures. Learned advocate for the petitioner is directed to file affidavit of service in respect of the other respondents on the returnable date.
Students has been returned by, so this service may be direct.
So it has not been served.
Who has accepted receipt? Who has been returned? To return.
Learned advocate for the petitioner seeks to serve afresh upon respondent numbers
3 and 4.
3 and 4. Apart from the commission, who are the other respondents? Give the numbers. 2 and 3. Let such service be effected upon respond numbers 2 and 3 to register speed post with acknowledgement due and affidavit of service be filed.
When she is already appearing.
Huh?
When she is appearing.
File ta dao to file ta di.
1, 2, and 3.
Has been served. Because my learning friend had received the
1, 2, and 3. 4, 5, 6.
1, 2, 3.
4, 5, 6, 7 করে দিন ঠিক আছে Madam is appearing for 1, 2 and 3.
Yes, my lord.
Then 4, 5, 6 and 7.
4 man.
4, 5, 6 and 7. Huh? Correct. This matter after 2 weeks. Service.
It will take 1 week.
After 2 weeks. Pause the service and come back. Yes.
Can you actually publish my fix a date?
It will be after 2 weeks on Wednesday. Wednesday is the madrasa matters will be taken. Yeah.
Item 20.
Well, I am for the state respondent.
Yes.
This is affidavit of service.
What is the prayer?
The petitioner before Lordship Malad, the headmaster of Malad Madrasa. Malad Madrasa was upgraded Malad. Session Malad 2010 and 2011. After Malad higher secondary Malad upgraded, Malad petitioner obtained Malad 3% additional increment for discharging Malad as a headmaster of a higher secondary institute. Thereafter Malad petitioner retired from service on Malad 31st May 2020. After retirement, my lord, when my petitioner went for my lord, his retired dues, the DI my lord directed to refund the my lord entire amount where my lord he obtained my lord as a headmaster of my lord of a higher secondary school. That 3% my increment. Otherwise, my lord, incremental benefit was not be released. And my directed the school authority.
Where is the order granting him 3% increment?
Malad, no order, Malad. When Malad, it is automatic. Malad 2009, as per Ropa 2009, Malad, when Malad institution upgraded from high secondary, then Malad, it will he will obtain Malad 3% increment. Malad, after Malad,
Same institution has been upgraded as a high school.
Yes, Malad.
It was class 8.
No, Malad, high secondary.
Okay.
High school to high secondary.
Okay.
As per Ropa Malad 2009, Malad. But after retirement, Malad, DI said, Malad, you refund, otherwise, Malad, it will not be released. Thereafter, school authority, Malad, after deducting that 3% increment, Malad pension paper, Malad sent. Thereafter, Malad petitioner refunded Malad at entire amount. Thereafter, entire Malad retired his Malad released. Petitioner Malad after thereafter filed a writ application, Malad, challenging that Malad order. Writ application allowed. And directed the authorities to refund the entire amount with 8% interest. Petitioner all in Malad benefit Malad petitioner obtain Malad. But Malad the retired after Malad the retirement Malad his Malad pensionary benefit Malad release Malad without Malad counting Malad that 3% Malad incremental benefit. That Malad amount Malad without taking into consideration Malad entire benefit Malad release. I pray for that amount Malad.
But then you say that the amount has been refunded pursuant to the order of this court.
Yes, Malad. That order I annex Malad that order.
If the amount has been refunded, then what remains to be paid to the petitioner?
Malad pensionary benefit without Malad that amount Malad has not Malad count Malad that 3% incremental benefit without counting that Malad that has been released Malad. That issue Malad Malad 2009 Malad.
The treasury thing. If it is had to deposit someone with
I made a representation.
Now this amount 176812.
Malad.
This includes the increment amount that was directed to be paid by the petitioner to the authority.
Yes, Malad. Obtained.
Which he received at the time of while he was in service, which he has received. But the authority says that no, you are not entitled, so you refund the amount.
Refunded.
So that we can disburse the payment, pension. Now you have deposited that.
Yes, Malad.
If that amount has been refunded pursuant to order of this court, what remains to be paid by the authority?
Malad, when Malad pensionary benefit Malad counted without Malad taking into consider Malad that 3% amount. That one even petitioner Malad obtain Malad pensionary benefit Malad pension Malad without counting the 3% incremental benefit.
Okay.
Malad school authority are directed to send the pension paper
deducting that 3%. Thereafter, my pension was sent. Thereafter, released.
No.
So, my petitioner of the my pensioner benefit after deducting 3% income tax benefit. Petitioner refunded that amount, but that is another thing.
My lord, the case of the petitioner is that, my lord, while he is in service, my lord, he is giving 3% additional increment. My lord, after the retirement, just before the retirement, the DI has initiated proceedings calculating that amount has been overdrawn. My lord is well aware that regarding Shambhavu Verma and all the cases of overdrawn, that has to be refunded. That has been refunded. Now it is the claim of the petitioner that he is entitled for additional 3%. Whether he is entitled for the additional 3%, the calculation of entire benefit has to be done by the pension sanctioning authority. To that effect, my lord, he made a representation at page 62. May I pray before your lordship, my lord, let the pension sanctioning authority, that is the DI, is taking the decision whether he is at all be entitled or not. If he has been entitled, my lord, the benefit should be granted. And if he is not been entitled, then my lord, well, I think
identical order was passed by the coordinate. This is, my lord, the regarding 3% additional increment. Now the RUPA 2009, amendment of RUPA 2009, there is a cut-off date, 27 February 2006. Up to 2006, those headmasters taking responsibility of higher secondary section, they are entitled. Now in 2014, cut-off date was lifted. 2017, 2014 circular was withdrawn. Now the coordinate bench set aside that 2017 circular, observing that all headmasters for taking responsibility of higher secondary section will be entitled 3% additional increment, which was done in 2009 ROPA. Relying the judgment of the coordinate bench and the honorable division bench, this honorable court directed the who made a representation to consider the representation, who did not make a representation, liberty to apply the representation before.
But exactly my submission.
This order can be, it is also, the refund the amount. Thereafter, pension payment order has been passed. Petitioner was given liberty to file a representation and to consider this.
Here the petition has already made a representation.
My question is that if it is refunded, then what amount remains to be paid?
My lord,
because in the earlier writ petition, he says that there is a overdrawn.
My lord, all the
basis of the overdrawn.
My lord, all the claim of the petitioner is roaming around because of the, my lord, there is a recent judgment of the honorable court. After that judgment of the honorable court, well, it is held that he is entitled for the additional increment of 3%. Now all the persons are coming before your lordship that I am also entitled for 3%. That's why, my lord, this kind of claim. And for that reason, my lord, the pension sanctioning authority should be directed to look into whether he has exercised or whether what terms he is being entitled for that.
Refunded that amount which is obtained, but when calculation with the pensioner benefit, then that will be, it will be increased.
But then that amount is also to be adjusted, which has been refunded back to you.
Decision of the DI,
because they say that that is over.
That amount
your lordship is absolutely.
Where in your writ petition, the early writ petition, probably you have stated that you have deposited the overdrawn amount.
Yes, I annexed that order.
Page 59. Page 59.
Abar kindly say that.
দরকার নেই, page 59 এ এটা রেকর্ড করা আছে. Page 59.
Overdrawn amount.
Yes, madam.
This you have stated in a representation that you have been refunded with that amount.
I think I have stated in that.
To refund a sum of rupees at all.
My lord, at page 64, paragraph number 6. Page 64, paragraph number 6.
Refund. Asun, affidavit service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for direction upon respondent number
specifically respondent number 3.
3. DI?
Yes, respondent number 3.
District Inspector of Schools to recalculate the retirement dues, including the pension of the petitioner, by taking into account the 3% additional increment for performing additional responsibilities as headmaster of the institution, namely Higher Secondary Madrasa, from 1st July 2010 to 31st May 2020. The petitioner contains that he joined as what was your initial joining as?
Assistant teacher, thereafter
Assistant teacher in Uttar Lakhimpur High School. Which was subsequently upgraded to higher secondary school. Same school. Sir, same school.
No, man. Transfer.
No, which school has been upgraded?
The ideal high madrasa.
The petitioner was subsequent thereto, the petitioner was appointed as headmaster of Ideal High Madrasa. The petitioner retired from service on
31st May
31st May 2020 on superannuation.
Thereafter, page 59.
Okay, but matter is not proceeding, not proceeding. Only part of it. Come to paragraph 8. Paragraph 8, specifically page 7. See, he says that the paper and before superannuation pension paper was sent to the concerned district inspector school by taking into account the aforesaid 3% additional increment benefit for performing additional responsibility headmaster, but the matter was not proceeded. And after superannuation, the district inspector of schools concerned directed your petitioner to refund a sum of rupees 176,812, which was drawn by the petitioner due to fixation of 3%.
All the claim of the petitioner rises because of, my lord, judgment passed by this honorable court, which start from page 49. These type of cases, my lord, there is a direction of the honorable court to grant additional 3%. Prior to that, my lord, that was not there. Thereafter, my lord, all these representations and
The petitioner entitled to benefit the pension was not granted and the petitioner was directed to refund a sum of rupees 176,812. as an overdrawn amount. Accordingly, the petitioner deposited the said amount with the concerned department. The pension was accordingly granted. Upon refund, the pension was granted?
Yes, ma'am.
Pension
Date
was
minor,
granted.
page
The
59.
petitioner filed a writ petition being WPA 19271 of 2023 seeking for refund of the overdrawn amount, which was allowed by this court on 25th August 2023 as follows. Accordingly, page 61 set out dark below. The petitioner thereafter made an application before the which authority will refix it? Director of pension.
No, DFIX is a district inspector of school as because it's a pension sanctioning authority.
Made an application for refixation of his pay with effect from 1st July 2010 to 31st May 2020 before the director, district inspector of schools, including other authorities, on 12 June 2025. The same is still pending with the authority, hence this writ petition. Learned advocate for the petitioner, Mr. So-and-so, learned advocate for the petitioner, seeks that the matter be relegated to the respond number 3 for consideration and disposal of the application of the petitioner dated 12 June 2025. Learned advocate for the Mr. So-and-so, learned advocate leaves the matter to the discretion of the court. Accordingly, represent parties in which will be disposed of within a period of respond number 3 core beta. Within a period of 6 weeks from date of communication of this order. Upon notice to the petitioner.
And my lord, as well as the madrasa authority.
As well as the which respondent? Upon notice to the petitioner and respondent number?
Six and 7.
7 is the school.
School.
Okay. 6 and 7. Disposed.
Grateful. Grateful.
All right. Article 21.
My lord, learned senior advocate Potik Dhar engaged in court number 18. Kindly pray for not today.
Not today, next week.
Appear on behalf of the state trust.
No, 22, I am for the petitioner. This is also my lord, the identical as 2020, but petitioner is still in service for taking high responsibility. My lord, he demanded 3% additional increment. My lord, I am not my lord, reading all the circulars. My lord, my learned senior friend is also appearing. Your lordship may pass this order directing the liberty to the petitioner to make a
Lord, I have.
representation.
Oh, sorry. Let him.
To make a representation before the district inspector school. District inspector school will consider and pass a region order in accordance with this.
Lord, I have got my instruction. Lord, your lordship kindly look to R1 of the recent government circular. Your lordship. 23/2025 আমি দিই জসবকাকে দিই না তোমায় দেবো লর্ড ইউর লর্ডশিপ কাইন্ডলি ব্রাউজ অফ দ্য লাইনস হ্যাঁ দিচ্ছি page 4 your lordship the latest circular lord that is in consonance with the order of the Ashim Kumar Rath para 4 5 and 6 দেবো তোমায় চিন্তা
This is my favor.
it's not that but your lordship kindly see that
subject to paragraph number 5. Lord, may I read it out?
Yes.
It also appears that a similar matter of WPA number 24816 of 2022, Sri Ashim Kumar Roth, which my learned friend also perhaps is relying. Passes the state of West Bengal, the school education department has allowed Sri Roth to continue with the additional increment of 3% based on an undertaking given by Sri Roth to the extent that Sri Roth will refund the money if the government in future, as a matter of policy, asks him to refund the money along with other similarly placed headmasters.
Yes.
This is the condition.
If it is allowed,
And undertaking has to be given by the petitioner.
yes, I will give undertaking. If in future there is any.
That is my latest circular, my lord.
No. Affidavit service filed on behalf of the petitioner.
Lord, may I take leave in another matter? I have
Yes,
to go
yes.
to Autonom. Lord, I'm extremely sorry, Lord. My learned junior friend.
Uh,
I have to run now.
Yes, yes. You will evidence filed on behalf of the petition is taken on record. Mr. By the present writ petition, the petitioner seeks for direction upon the
Lord, the policy, the letter, the instruction be kindly be kept on record.
Okay. Yes. Seeks direction upon কি বললাম? Upon respond number 3.
Respondent number 4. No.
Respond number 3.
Respondent number 5, Your Lordship.
But in prayer you have written 3 and 4.
The pair was respondent number. This is, since it is a madrasa, Your Lordship direct the respondent number 5.
5 is direct.
District he is the competent authority.
DI.
Yes, pair B is there. Pair B. ঠিক আছে। It's seeking direction upon respond number 5, District Inspector of Schools to refix the basic pay of the petitioner who is discharging function as headmaster of Budhia High School, High Madrasa, HS, upon granting him 3% additional increment in terms of government order number 181-AC within bracket B/5B-1/09 dated 8th October 2009. Prayer B ta dekhe neben. And other government orders of the year 2010 and 2014. Subsequent government orders of 2010 and 2014. নাম্বারটা এখানে পেয়ে যাবেন এই যে 10 এর একটা 9টা বললাম 10 and 14 প্রেয়ার বি তে আছে ঠিক আছে The petitioner contends that he is the headmaster of
Headmaster of Budhia
High Madrasa HS, which has been upgraded as higher secondary High Madrasa on 21st August 2008. The petitioner has taken charge as headmaster in the said High Madrasa on 25th March 2014. In view of the notification number 181-AC within bracket B/5B-1/09 dated 8th October 2009, the petitioner is entitled to get one additional increment, that is 3% of his basic pay and grade pay of rupees 200. Stop. Since the petitioner was not granted such benefit, hence this writ petition. Mr. So-and-so, learned advocate appearing for the petitioner, submits that in terms of the notification of the government of West Bengal, the petitioner being the headmaster is entitled to 3% increment, 3%, sorry, entitled to increment of 3% of his basic pay. he seeks liberty to submit a comprehensive representation before respond number 3, District Inspector of Schools, in this regard
Respond number 5.
for his due consideration in accordance with law.
Respondent number
Mr.
5, my lord, DI, respondent number 5.
5 5 করে দিন, 3টা 5 করে দিন। Mr. Oshim Ganguly, learned advocate appearing for the state, files a report by the District Inspector of Schools. ওটা পরে দেন। Submits that similar benefit has been extended to one Oshim Kumar Roth upon undertaking by the employee that in future, if it is required to refund as a matter of policy, stop. ওটা upon করবি না, upon undertaking. Learned advocate for the petitioner seeks to, you will give undertaking.
No, my lord, the
Seeks
if
that
policy comes, my lord, in future, then undertaking is required. My lord, I don't know, my lord, premature, my lord,
he
advance,
is
my
a
lord,
learned advocate for the petitioner, submits that the petitioner willing to execute such undertaking. In view of the aforesaid submission, petitioner is granted liberty to file a comprehensive application before respond number 5, District Inspector of School, who shall, within a period of, when can you file?
2 weeks.
Within a period of 2 weeks, stop, upon receipt of the same, the District Inspector of School shall consider and dispose of the same in accordance with law upon notice to the petitioner as well as respond numbers.
Respondent number, madrasa, respective madrasa, my lord, the 7.
Respond number 7.
Madrasa authority, your lordship.
Madrasa authority, respond number 7 করে দিতে। Disposed of. ওটা একটা ডেট দিয়ে দিন। এটা 2 weeks তো 2 weeks within a period of 6 weeks. Upon receipt of 6 weeks.
Only, my lord, there is my lord, the order in the coordinate bench. If the pair of the petitioner is allowed, then necessary consequential steps can be taken. My lord, can you add on?
Shall consider and dispose the representation if the petitioner is found to be entitled to, then necessary consequential steps be taken.
হলো তো 23 also same. Only, my lord, the date will be changed. Respondent number 5, District Inspector Schools, and my lord, the
Here you have made a representation? No. করতে পারবেন?
Mohammedia High Madrasa, respondent number 7.
ওই ওটাতে he files a report, ওটা বলেছি? হ্যাঁ? He files a report dated such and such, which is taken on record. ওটাতে অসীম গাঙ্গুলি একটা ফাইল করলো রিপোর্ট, না বলা থাকলে ওটা বলে দিন। ওই উপরে বললাম না যে ওটাকে নিচে দিয়ে দেবেন, উপরে স্টার্ট করেছিলাম। ঠিক আছে, শুনুন দেখি কি বলছে। Yes. Similar order may be passed in this.
That may be passed at the 23, my learned senior friend 25. My lord, he can appear, my lord, the 20.
Your lordship directs, I can appear, my lord, since the other side is not here.
You are for state.
I am for the state. In 25, I am for the state with
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition similar or increment. হ্যাঁ ফ্যাক্ট একটু চেঞ্জ হয়ে যাবে এখানে উনি জয়েন করেছেন
Page 27, Mohammedia High Madrasa, upgraded on 21st July 2005.
Item number কত?
This will be changed.
23.
পারবেন তো এই কি ফার্স্ট প্যারাগ্রাফে এই মোহাম্মদিয়া এই যে হাই মাদ্রাসা
Page 27.
ACHARYYA.
ওটা আছে মোহাম্মদিয়া হাই স্কুলে উনি জয়েন করেছেন 29th April 2014 upgraded on 21st July 2005 বাকিটা সেম আর এখানে কোনো রিপোর্ট নেই none appears on behalf of the state তো রবীন্দ্রনাথ চ্যাটার্জি না মিস্টার চ্যাটার্জি
শৈবাল আচার্য আচার্য with মহুয়া দত্ত বিশ্বাস
advocates who usually appears on behalf of the state is requested to appear in this matter. Let the appointment of Mr. So and Mrs. So be regularized by the concerned authority.
Well, regularized by the government pleader, learned government pleader.
Regularized by the LR.
Learned government pleader, because this
concerned authority. Petition is directed to learned advocate for the petition, directed to hand over a copy of the writ petition and the annexures to the learned advocates for the state. Learned advocate for the state leave the matter to the discretion of the court. Yes, similar direction. Disposed of. Liberty granted to file representation.
24 টাও সেম আছে
24, 25 both are same.
24 also same.
Next we will see.
24 also same.
Afterwards. Next week.
My lord,
25 I am appealing, it can be the similar order, my lord, it can be disposed of, subject to your lordship's convenience. I cannot pressure your lordship.
We'll meet in the next week.
next
Very good.
Wednesday, come on 20.
24 ওয়েডনেসডে থাকবে আজকে হবে না নেক্সট বুধবার আছে এই শৈবালদার আমার নামটা দেখেছো এই শৈবালদার আমার নামটা দিয়েছো বলছি কি দাদাকে বলো
দেয়নি তো